Okay, good morning. Morning, everyone. We've only got a few of us here in this huge big room, which is good, and lots of people sitting online. So I'm just wondering for a volunteer for a karakia to open. One of these Antoine, if no one from the is putting their hand up, perhaps you could open us with a karakia, please. Can you hear us, Antoine?
Yes, I just can.
Yeah.
You're happy to do that. Kia ora mai tātou, e te tīmatanga o tēnei rā, he tukunatu ngā mihi ki tā tātou kaihanga nāna nei te tīmatanga, nāna nei te whakaoti ngā mea katoa. Nō reira whaikorori harerea ki ngā mano, mātua tama wairua tapu mena pono me te māngai. Tātui ki te kauriki wairua te arapatapa te omaka puri uri tua. Hāmura te tīmatanga mo e tō ngā mātua tumatua nei ko te māngai no hei tautuku mai ai ni ākini ai. Ai te māngai na pono to tokotoro tapu kia tatu mai anō koutou ko wainga nui ki tēnei whakamoimatia mātou. Hei tātari ngā kupu kātua e whakapua kena nā mātou e roto koutou korooriatanga ko te māngai no hei tautuku mai ai ākini ai. Ko ngā kupu e tika ana e pōnana kia whakaungia mai hei oranga tinana, hei oranga wairua anō hoki o koutou pōnanga. Ko ngā kupu he kātua kia tahuna atu ki tā koutou ahi kia pungarehu atu i runga e anao e te tukana ihoa ko koutou aroa no i te tokotoro tapu mi ngana hera pono ko te māngai e no hei tautuku mai ai ni ākini ai. E te māngai na pono te tokotoro tapu uhia tō koutou aroa no ki runga i ki tēnei pono ngā koutou me ngā anoa ia kia ki te māramatanga i o koutou aroa no kia whakapono ai te whatu manua me tōna wairua. Ko koutou te mauri o ngā mea katoa, kia wehi ai, kia koe e ihua, mātua, tama, wairua tama ngana poina ka te māngai anō hei tautuku mai, ai anei ākenei. Āmeni. Kia mai tātou.
Thank you very much, Antoine. I think you can see a side profile from me, so I've got to keep my chin up or try and do that, but it's a bit of
it's your good side though, Stephen, so don't worry.
Looks like a secret cam.
So just get used to that. I think there's a folder in the way, so I'll move that out. It's probably a bit better. Yes, so welcome, and just looking around the room and obviously on the screen, we've all had the intro regarding the hearing. This is day 6 of hearing 5, and I won't then go through the introductions and the normal things, so we're into things. And just reflecting on yesterday, 2 very big days, and yeah, pretty tiring for everyone. I understand that, particularly for those beaming in from outside, but for all of us, I can see the eyes drooping a bit at the end of yesterday. And we did introduce some procedural matters, or just basically table what we wanted to talk about. And we will start with those this morning. Again, the panel has had a conference this morning to discuss a number of matters. And I'd just like to go through the matters in order. So the first matter, and I'll need to speak with you, Ms. Wakora, about this, is in relation to your further legal submissions. So you're there, Ms. Wakora? Yes, there you go.
Yes, sir.
Yes. So we had that discussion about your offer to provide us some further legal submissions on quite a number of matters that of clarification and further assistance to us, and we're very grateful for that. We're also mindful of the fact that this is, a significant hearing for the district. It's raised a range of very important issues which we don't want to rush, and the parties, I think, have really benefited from listening and hearing the different sides and the issues, and we're all working together, I feel, very positively to really make the very best decision that we can on this important aspect. So,
Yes, sir.
and you'll see when we come to the witness or the conferencing that we've asked Ra to organise, we have reflected on sort of the time frame a little bit on that. So I think if we agreed yesterday, if you could have those further submissions to us by the end of tomorrow, that's still acceptable to you while it's all fresh, that would be great if that's achievable.
Yes,
I
sir.
just wanted to double check on you that's not putting too much pressure on you in terms of your
not at all.
your workload. Okay.
No. Can I just add, Sue, that if you have any further matters that for which my engagement is required, I do have a doctor's appointment that I need to attend shortly after 11 a.m. this morning, so I'd really appreciate just reflect that in any discussion and timeframes.
Yes. No, look, I think between us, the panel and you, we've pretty well negotiated the range of matters that
Lovely, thank you.
have both been volunteered and requested. And I think you're clear on those
Absolutely clear on that. I just wasn't sure whether other points of discussion might require my input.
Nothing that spring to mind. So thank you. But there is one particular issue which we did touch on yesterday. It is the letter I've received from Mr. Buttermore, dated 8th of October, on behalf of PKW, requesting I consider a possible limited re-notification of matters associated with Puke Iti. And there's a couple of questions really I have reading that through. Do you have that in front of you, Ms. Wakara?
I can pull it up, sir.
So firstly, are you acting for PKW as part of your brief?
No, I'm not.
You're not. Okay. So this is something quite
that
separate.
has kind of come in through. I understand that that has come in and been provided to Ms. Mako, and so that's why it was produced.
All right. So you're not acting on this particular request in terms of.
So I understand. So in this context, I understand it's a matter of discussions between Ms. Mako and the, I can't recall his name, sorry, but the named person in the letter in relation to PKW resulted in their decision to write the letter.
Okay.
And she has provided it to the hearings administrator in that context.
Okay. So look, I think we should hear from Ms. Mako on this now. I think the intention, Sarah, was for you to table this yesterday and introduce it. Is that right? Yes. If you come up, yes.
Kia ora, man. Kia ora, morena. So a bit of context. So the office of Te Kotaitanga o Te Atiawa is in the Paraninihiki Waitotara building. So we have a very close relationship with them anyway. So I was able to work closely with Richard Buttermore to confirm that they did support an ONFL there, that PKW did support that, and as a result, Richard had prepared that letter, keeping in mind that I've done this in sort of a coordination of that, of all of the iwi and hapu submitters, and Puke Iti isn't actually in Te Atiawa Rohe. It's in Taranaki and Taranaki iwi rohe and Ngā Mahanga Atairi.
Okay. So,
I've done that between working with both Taranaki Iwi and Ngamahanga,
okay,
just as a coordination.
okay. So because of that, I think we'll deal with this separately and respond perhaps, but there are a couple of clarification questions I wonder whether you could help us with. The first is around the first paragraph. Do you have the letter available? Or... So just a first point of clarification is in the first paragraph where there's a sense given that there were some problems with notification as PKW saw it. Do you know any, can you provide us any further advice on that?
So obviously just speaking as a
messenger?
A messenger, yes,
Yes.
and not at all for PKW, but I understand during the, and actually Sarah Edwards may be able to provide some context as well, during the notification of the submission and the further submissions, how PKW are, I guess, registered within the council's system is that they have a number of lessees as well. So they're the owner of the land, but they have lessees. And my understanding is that in the notification of the plan and the further submissions, that some of the letters, or a number of the letters, maybe all of the letters, I'm not sure, didn't actually make their way to Paraninihiki Waitotara. They went to the lessees and they weren't passed on. It was only very late in the stage that that PKW realised that the plan had been notified.
Sarah Edwards, is that? I know, but we're really just reaching for a bit of background knowledge here, and so certainly anything you could add to that. We are going to have to seek advice from the council on this formally anyway, but anything you could add just to start the ball rolling would be good.
Sorry, this is really delving into my memory from about 18 months ago, but there was some issues, and as Ms. Marco has described, that's essentially accurate. What it comes down to is there are a number of lines in our system of with all the different parcels of land that are owned by PKW, and with the lessees, various letters are sent out. So some letters went directly to PKW for some parcels of land, and sometimes they went to the lessee. And it's mainly to do with where there was a site of significance to Māori on the land, or a rezoning, or some sort of special feature. So in that large mail out we did, where we contacted around 8,000 letters, in there was a mix of PKW direct and to their lessees as well. Now, I did write to their corporate manager about the issue, and between us we navigated how the notification had gone, and what were the next steps were. But I can't recall how that finished. I'd have to go back into my emails and find that contact at that time.
All right. That
Can't recall. Sorry, Sarah's just asking me, did they submit their submission late? And I just can't recall.
Okay.
I'd have to go back and
yeah.
check.
So look, as I say, we'll deal with this as a discrete matter. I'll have to think about information gathering and how we respond to that, and we can take that forward. So the second area of initial clarification is in paragraph 2, where it said that notwithstanding those issues around notification, there are 2 submissions that have sought the inclusion of Pukeiti as an ONFL. And my question, if that's the case and there is scope, why do we need to re-notify? Why is there a need to re-notify?
Stephen, if I can jump in there. I mean, I've had a look at the 2 submissions, and I think Mr. Buttermore is actually referring to further submissions, because it's quite clear that both Te Kahui o Taranaki and Ngā Mahanga o Tairi lodged further submissions supporting this as a separate relief point, but it was in relation to general submission by Transpower about amending the provisions around ONFL rules.
Yes.
So it comes down to whether the further submission gives scope, and I guess to some extent that's something we could potentially get advice from Ms. Wallace on, as well as whether there is or was some form of legal error in the notification process, which could give rise to liability from the council's perspective, that then might lead to a re-notification.
Okay, that's very helpful. Thank you. Yeah, so look, I think that's about as far as we'll take it. We'll just for the record, certainly acknowledge receipt of this letter from Mr. Buttermore. I think Julie and Christine, we need to get this up on the, obviously up on the website and things in due course as in whatever category is appropriate. And we'll be issuing some instructions around this over the next few days to a week. So thank you for that and being the messenger. Sarah, is there anything else you wanted to say?
Yeah, I just if I can just add one thing, and Maya might want to jump in as well. Is so we've been talking with myself as the coordinator and Maya as the legal counsel around a process for this, and not entirely relying on a we've set out a process, and we're not totally relying on just that legal advice being received. That this is actually a partnership between Taranaki Iwi, Ngā Mahanga, Tairi, Taranaki Regional Council, and Paranini Hiki Waitotara. So just to let you know that that's also happening in the background.
So just knowing about the partnership and the positions of those key parties is going to be critical to however this is taken forward in terms of process or timing, I think. But just from a representation point of view, because we are going to be delving into needing to get legal advice, my question to Ms. Wakaira was, in terms of, we're not anticipating you will be addressing this in your further legal submissions on the matters around this hearing, Ms. Wakaira. That's just to double check.
So you had asked me questions about those cases in respect of the cases that I spoke to, and the other instances I'd spoke to. You'd asked me to address those matters in more detail.
Yes.
One of which relates to the prospect of a variation, which I see as actually potentially a far more favourable outcome, because it doesn't require the panel to direct the matter. It'd be a council initiated variation.
Yes.
And of course that would lend itself towards all of the parties being agreeable to any additional amendment. And so that's, I had noted that I would speak to the Plan Change 1 variation in relation to the Waikato Regional Plan, because that arose in discussion during the presentation of my legal submissions.
Yes.
Just to assist in terms of that being a potential pathway forward.
Yes, and I mentioned the Queenstown Lakes one where...
Yes, you mentioned Queenstown Lakes.
Yes, where I think there might have been a bit of a wake-up moment partway through those hearings, and that council withdrew and get some more work done and issued a variation. That's my rough understanding of that process. I've been observing that from a distance. So yes,
Yes,
so
sir.
you will be addressing some of those mechanisms in your further submissions. Okay.
Yes, so just by way of options, but if you were referring specifically to the letter in any legal issue, I hadn't intended as a consequence of our discussion prior to address that particular matter, and I wouldn't be aware of the detail of any notification issues to be able to do so, I would say.
Okay, so just
That's far better to come from Ms. Wallace, as you've noted.
Yes, okay, thank you very much. Any other questions around this point, panel members? Right, we'll move on now. So that's the second issue we wanted to cover. The third issue is about the conferencing we've asked for, and that brief discussion we did have yesterday brought into focus some of the procedural options I think we have about what's requested, what's delivered, timeframes, those sorts of matters. My first comment is that, after talking with the panel, we think that we just need to make haste a bit slowly on this one. And we would like to, we've heard the questions from you, Ra. We've heard that maybe you're getting underway in a couple of days. We'd like to take some time to reflect on what might be the most useful outputs for the panel, because that's what it's all about. You would have heard my discussions with some of the witnesses about the duties as planners to the panel under the code. They're not there as advocates, so we certainly don't want to be receiving sort of, if it was a joint witness statement with just planning experts, that's quite different to all parties involved, let's compile the best information set we can about the different positions. So there are a range of options we could do. So we've decided to pause on those instructions and to issue a minute to the parties about what our expectations and requests are. That does mean that, as I've indicated a couple of times, that hard write a reply deadline 2 weeks after the hearing finishes will be part of our considerations, that if we do need some more time, and I think we do need some more time, we will set that out as well. So if we can leave it at that, just stand by for those, but you may have some other comments and questions on that now.
Just to let you know that in preparation for the conferencing, I've sort of compiled a matrix that breaks down all the rules and what these planners in particular are where of, you know, some analysis of where the differences are. And just with quite a few parties involved, I thought that would just mean that session could be a bit more efficient. So it may be that I could sort of collate those section 32s in there, and then we could I could present that, and we could have a session to confirm those details and positions, and if possible come to some agreement around particular provisions. But yeah, I felt that was quite useful exercise for me to see where those differences are, and I'm going to be using that as sort of the basis for what I talked to you about today as well. Okay,
so it's worth having a discussion with you and others on the panel, because we've all had different experiences of a range of useful processes. And I've mentioned to the panel this morning that certainly yourself and Ms. Mako, we've been involved in other hearings where these sort of processes have been very useful. And but it's a question of what the outputs that are going to assist us most. So are you suggesting you're already underway with that matrix? You've already prepared that?
Yes, I mean, it's draft, but I think it highlights the provisions and the key things that the different planners are requesting.
Yes, and that is,
I almost wondered whether that was what the output that you were after. But
well, that was in some of our minds what the output was.
Yeah.
And your session that you're planning for Friday was to just clarify that with the
Yeah,
other planners?
I thought to step through those provisions, in particular, I thought it would be useful to see if we could work on that consent pathway, particularly Eco R1.
Yes.
And the P3 and P4 would probably, yeah, see if we could come, I think that they need amending.
Yes.
And see, yeah, if we could come to some agreement about those.
Okay. Look, I'll bring the rest of the panel in on this discussion just to see any further reflections. Maybe starting with you, Kit.
No, I think I'd be interested to see what Ms. Macbeth has prepared, because to my mind, that was one thing that I thought we'd be quite assisted with. So yeah, I mean, let's just roll on, and I think we're in good stead once we see that to then really focus what, if anything else, we might like in a minute. That would then lead to a process to gather that information in advance of or as part of the council's reply.
Okay.
So should I forward it to you? It is a draft.
Look, I still think we need some further discussion just now about that output, which I agree that's certainly going to be very, very helpful. You'll see we're scrabbling around amongst lots of different documents. But my questions are, and I like the panel's advice on this as well as part of a discussion, is you've already done that as a starting point, and that's an enabling memoir for your discussions with us and your verbal summing up. Seems like you've already teed up a session on Friday afternoon with the planners. Question is whether we should proceed with that, given the questions we had yesterday about participation in that session, and whether it should be restricted to qualified planners or other parties. So just on that point, David, do you have any thoughts about that?
Yes, sir. I'd endorse what Commissioner Littlejohn said. I think we could split this into two components: a factual summary of where the parties are and what their relief in the current format is. And it sounds like Ms. Macbeth made a good start on that already. And if the Friday session was to proceed, that might serve to fine-tune that. On receipt of that, the panel might then be in a position to issue a minute that's set some directions and some questions to be answered in a thematic sense. I think that would be useful, and it would certainly help the panel and receive information on what they think are the determinative issues. So I think I'm supporting of that two-step process, sir. I think it should relate to all the rules in the chapter, not just the land use rules, but also the subdivision rules. I think there was some mention yesterday from one person, it might have been Ms. Macbeth, that focus was going to be on land use, but I think subdivision is squarely part of this. So I think that factual summary and any subsequent direction should extend to all of the policies and all of the rules. So yes, a two-step process would be one that I'd support, sir.
Just in respect of the subdivision, I think most of these planners haven't really submitted on the subdivision rules. It might be more appropriate as a separate session with those that have submitted on subdivision, being Tangata Whenua, Ms. Johnson, and then Mr. Kiss, if he's determined
Yes.
planning expert.
I'm referring to rule 5 and 6 in that sense, as opposed to the rules in the subdivision chapter.
Yeah, and understand that, but the likes of Transpower, Trustpower,
yep.
They haven't submitted, the evidence didn't cover the subdivision part of the eco chapter. Right,
noted. And for that reason, only those that can participate on those are only those that submitted.
I think
we're hearing maybe splitting it up.
Splitting it up, yes. Commissioner Coffin, do you have any thoughts on this course of travel?
Excuse me, I'm just stretching my legs. It's only 10 o'clock and my legs are getting sore. It was just, I didn't have anything further add there other than I think we're going to have a discussion shortly about who should be attending. And I think there's a question about whether we have the expert planners, those who have signed the code of conduct, or it's a session on planning associated to these particular sections of the plan. So that's a moot question.
Okay. So we have had some discussion about that this morning again, in terms of this is, I think is succinctly put by David to us. Is this a session, is this a planner's session, or is this a session about planning? And sometimes, or when a joint witness statement is produced by experts in a field, that is limited to qualified experts, where they might be whatever, landscape experts, ecologists. That is quite restricted, and that does become evidence in front of us. So that's one approach. The other approach is a planning session where those parties that have produced evidence, whether they're experts or not on the topic, and I'm thinking about Ms. Walker, for example, and Mr. Kiss and others. That's a more open process. And I'm just wondering what your preference would be, Ms. Macbeth, on getting the best value out for what you're doing.
In particular, with federated farmers, I would feel a little bit uncomfortable redrafting that workable rules approach without understanding federated farmers' views, considering how involved they have been in developing this approach.
Yes.
So,
but they haven't produced a rules table, have they?
No.
No. Yes, but on the other end, at the other end, Forest and Bird have produced now.
Yes.
A rules table, which I think has been circulated. I haven't actually seen that, so perhaps that has been circulated to the panel and the parties. I might have been.
I know they get to go up on the website. They're the ones I.
Yeah. Yes. So we do have. We were asked, was it Mr. Webster?
Jennings.
And they have produced their table, so we have that as a tool. So I don't think this is a process that we need lawyers to be involved in, and given that Forest and Bird have produced the document which you can sort of put on the table and include in your matrix. But yeah, so your preference would be to have it broader practitioners rather than just planners that have produced evidence?
I guess just an opportunity to run it past federated farmers, what the planners come up with.
Yes, but there was Ms. Marco, there was involvement, also Mr. Kiss.
Yes, those parties as well.
Yes, yeah. Sarah's got her hand up, so.
And also, I was wondering if the ecologists are involved, then perhaps Maori Gregory Hunt should be involved as well. Is that all right?
Yeah, I'm not seeing this as an expert ecologist session. This is a planning session. Commissioner McMahon, please come in.
Thank you, Stephen. I just wanted some clarification about whether the planning versus the planners session related to step 1 or step 2 or both. Because step 1 in my mind is purely a factual presentation of the summary of the relief and how it relates to each other, whereas step 2 is an evaluation, in my view, of the best fit and what changes might be necessary. And I think step one is a really valuable input. And I think everyone in the tent should be involved. So that's the planning component. But step two might be, particularly if we're looking for a joint witness statement, might be best limited to the experts who have signed the code of conduct.
Yes, okay.
With step one, though, how far would you go with that? Because we've got a lot of recommendations for things to be allowed for in rules.
Yeah.
Such as, yeah.
It's hard to know, I guess once we see what you've produced this morning, and for me this morning's about listening as opposed to questions. I'm equating step one to an inventory of the range of relief and how it relates to each other, so everyone knows what's on the board. How that then gets reorganised, I think, is then the function of step two. And if we as a panel can help direct you, for example, and just drawing on Commissioner Littlejohn yesterday, we talked about a middle ground for perhaps enabling a limited number of what might be termed appropriate activities, access tracks, maybe infrastructure, I don't know. You know, we might direct on a without prejudice basis some drafting assistance on that from the expert planners. That's not to say we would run with that, but it would be nice to, might be nice to see how that shapes up. So that would be definitely a function of step two as opposed to step one.
Yeah.
Hopefully that answers your question in some way.
So I would say that I have drafted step one to incorporate the requests within the evidence of expert planners. So I haven't gone wider than that with, you know, requests about landowner access tracks and
Yes,
that sort of thing.
and that would be my expectation. That would be a function of step two.
But we still have a debate about those parties that haven't presented via an expert planner their rule tables. So on one hand, Forest and Bird have, yes. On the other hand, Federated Farmers haven't, yes.
That's great.
And Ray, you're saying that you would, and maybe we should speak to Ms. Walker now, you know, as we've asked for the other parties, whether Federated Farmers should be putting together their rule preference, which reflects their submissions and their position. Ms. Walker, what's your feeling on that?
Yes, so good morning. Yeah, I guess so just by way of explanation for our hearing evidence, and as I say, it was, and as you will have acknowledged, it was relatively different to the way feds would normally approach this part of the planning process. That was very much because we are comfortable, and not least of all because of what's been already explained, that feds were really heavily involved in the drafting process. And so there was a sense that a lot of that, and I won't describe it as heavy lifting, I guess, but that a lot of that heavy lifting had been done. And so there was some discussion around how much resource, I guess for want of a better word, gets put into supporting a planning response. So which is essentially where we're at. Now as I say, there's clearly room for improvement, as is always the case through this, and often it's not until you get to the stage that some of those issues become much clearer through through some case studies, as we've seen, and as evidence drills down deeper into the rules framework, and I guess that policy framework. Yeah, so maybe I should apologise that we took it a bit lightly, and not disrespecting the subject matter, because as you will also understand, these topics are very important topics to Federated Farmers and to our members. So we weren't dismissing the importance of the topics, we were just comfortable with where the notified plan landed. And so that's why I didn't put up a new rules framework, because there were pluses and minuses and overs and unders, I guess, and to the extent that we were relatively comfortable with where it landed. Now, I do need to be clear, that position was already a compromise, as I think we tried to make fairly clear, and a concession on behalf of our members, and much movement from that is going to be interesting for us and interesting for me to work through to getting a mandate to what our position would be. But and then I am speaking directly to that general clearance rule, which from our perspective is completely unworkable as it's proposed, and there would be strong pushback from us in that space if it was in the parameters of what's been put on the table at the moment. Now I will qualify that, I guess, with saying that there is a middle ground, I think, that hasn't yet been explored, not least of all with those thresholds for what could be a general clearance rule, but also with the consenting pathway, which I think would be really important for us to be involved in. And if you did want, I haven't put my qualifications or experience because I guess I have been really mindful of crossing that line between advocacy and planning evidence. I'm not a planner, by the way, I've made that clear, but I have got a law and social science degree, and I've worked in this space for, nearly 15 years really. But that is all with federated farmers, but it has meant I understand RMA planning instruments and have been involved in, many planning development processes around the country, so and have access to that obviously through my colleagues. So we absolutely have value to add to this space, but I will but I fully accept, I'm not an expert, I haven't signed the code of conduct. I was mindful of that line crossing that can happen in that space, so I guess I kind of erred on the side of caution around that, and I'm not a lawyer, so I'm not holding myself out to be one either. I just have the law degree. So I don't know whether that helps a little bit, but maybe it just.
I think, Mr. Chair, I think what all that indicates, if Federated Farmers' position is that they support the rules as notified, then that's the starting point in this compilation of positions. So, with a series of columns, you'll have the plan provisions as notified, and then there will be parties who marry themselves to those, and Federated Farmers will be one of those. Then you'll have council's recommended changes to the provisions, and then there will be varying degrees of distance from those two as you go across the columns. Now, it may be in the course of preparing that, Ms. Walker can go to the members and say, look, there's some migration of the rules, and you should feel free to indicate because ultimately you've still got your right in your submission to challenge whatever outcome if you're not happy with it. But it may be that as a position, you could suggest in the table that, well, actually this suggested change in column 3 is acceptable to Federated Farmers, or you don't have to. I mean, as far as we're aware, you can sit as the party that supports the plan as notified. All it does is, from our perspective, give us a range of positions that we can then focus any recommendations that we make to the council around. So no one's asking Federated Farmers to change its position or do a whole lot of work to catch up. I mean, your position's clear from your submissions and support.
Yeah, no, I appreciate that. Thank you.
So I think we would need to draw the line, though, in terms of any phase 2, which we might direct, that for those parties that have called planners, they would participate in that. I don't think there'd be a role for those that have chosen not to be at the table if we do direct some further expert conferencing around particular planning issues. So I think the summary is, if the position of Federated Farmers is they support the plan as notified, that's what goes in your matrix. And that's what we've certainly heard today. Is there any other clarification you need for step one?
No, I don't think so. Just thinking that I would, in the matrix, include the likes of the requests to be able to trim branches under a certain size.
From Federated Farmers?
From some lay submitters.
Yes.
You know, so some of those workable rules,
Yes, those
things that we want to
workable
work
rule things.
with.
And if you just reference those to the submitters, I think that would be very, very helpful as a roadmap.
Yeah. So yeah, that might take a bit longer to pull those wider submission points in, but
Yes. So you've got, so let's just cut to the chase on timing. You've got a matrix, draft matrix prepared. You've had the benefit of this discussion today. You've got a session with some of the parties on Friday. When do you think would be reasonable to have the to report back to us on stage one?
I would suggest I would cancel the Friday appointment because I'm going to be pulling together much more broadly
Yes.
into the matrix, and yeah, the matrix is factual, and it, you know,
Yes.
what I've put in is basically just
Yes.
gone into those tables and
Yes.
collated that.
Yes.
So how about Monday? I could
Yes.
provide that table
Yes.
to you and then await further instruction.
Would you want to send that out to the parties as a double check, just to
Yes.
make sure? I think that would be useful. So if you prepare that,
Yeah.
and just to double check that, you know, they're comfortable with that representation.
Yes.
Um,
Yeah,
what
I
it-
think I would just send that to the planners.
the planners
Yeah.
and people like, you know, Ms. Walker's supporting.
Yeah.
You've got the position of Forest and Bird.
Yeah.
So you could just summarize that. But what I'm mindful of is that is what we've, the only issue I have in my own mind is staff have heard all this evidence, and you might have changed your position from your 42A report.
I think having that left-hand column with the provisions in the 42A report,
Yes,
and then I can put my thoughts
your thoughts
in there
down
as well.
Yes. And certainly I heard yesterday from the three iwi planners that they were thinking again about
P1.
P1 and some of their positions. So it's, so is
Could
it?
at least indicate where we think there's going to be talking and potential movement
Yes, I think.
with the matrix. I
as
think
a
that would
roadmap.
identify
Yes,
that.
yes. And I think some dialogue back and forth would be useful. We could do that by email.
Sure.
So could I suggest that we, end of Tuesday next week,
Brilliant. Yeah.
you give that to us with the dialogue as we've asked you to coordinate this as you can organise. Panel members, is that okay? Sounds like there's some nods there, or looks like some nods. All right, thank you for that discussion. That's been most helpful. That's everything that I had on my list. Is there anything I've missed from a procedural point of view?
No, sorry, just the query about Mr. Kiss and Miss Marco, but that would be stage 2. So you would
That's right.
advise me on that later.
Yes, yes. Yes, we would set out we would consider that as part of our directions if we do want to move to a stage 2.
Okay. So stage 2 is a maybe at this stage.
That's
you might
right.
get what you need through the
Yes.
matrix.
Yes,
Sounds good.
thank you. Probably just to round it out, Ms. Young, I did pose a question about your topics. They're not nearly as extensive. I think we've had some very clear evidence on that. So I'm not thinking there's anything in your space that would need to be covered in this type of process.
No, I agree. There's no reason to conference. It's very
Okay.
clear. Thank you.
Thank you. All right, so the purpose of today is to just hear back from the council team on their positions, having heard the submitted evidence and the questions of the panel, and whether you've got something, presume you've got something prepared. And we've also got some of the other experts. So who's available to us today in terms of experts?
I've got Mr. Bain. He's only available this morning
Yes.
for the natural features and landscape chapter, and I've also got Miss Davies for
Yes.
the public access chapter.
All right. Well, I wonder whether we start with you, Ms. Young, and then
Kia ora koutou. My name is Denise Young. I'm the author of the section 42A report for the natural features and landscapes chapter, which includes Schedule 8 and Schedule 10. This is Mr. Bain.
Kia ora.
He produced the expert landscape advice in relation to mikitahi and the height of structures. For conciseness, I will focus this verbal right of reply on the main issues that were raised during the hearing, but I'm happy to take any questions on any other matters that you might have. In this verbal right of reply, I will address my approach to the Commissioner's questions and matters raised by submitters in the hearing. So on day one of the hearing, I think it was Commissioner McMahon, I'm not quite sure, requested that I provide further advice on the panels, on how the panel's amendments to the strategic objectives align with my recommendation to include a new objective to provide for greater recognition for historic and cultural values in the protection and maintenance of ONFLs. I do note that in paragraphs 88 to 96 of my section 42A report, I discuss the submissions from tangata whenua that request the need for this new objective. And at paragraph 93, I do discuss the amended versions of strategic objectives HC3, NE7 and TW9 as set out in minute 9 of the independent hearing panel. And in my right of reply, I will discuss the relevance of the other strategic objectives, which I didn't discuss.
Thank you.
Do I just go on? Yeah.
I think so. So yeah, so you've got a number of topics you're covering. Let's pause it. You tell us when you think there might need to be any clarification. Okay. I'm happy with that, but there may be some other questions.
I'll just go on now to, that was the only question that I recorded from commissioners.
Okay.
I'll just go on now to the matters raised in the hearing.
Stephen.
Yes.
Sorry to interrupt, Stephen and Ms. Young. I might have missed it, but as Ms. Young's reading from some notes, will we receive those in due course?
Yeah, they do need to be tidied up. So
okay, that's fine. It'll just dictate the extent of notes I take, Ms. Young.
Okay. So the first matter that was substantive matter that was raised in the hearing was the inclusion of mikitahi as part of the Paratutu, Ngāmutu, Sugarloaf Islands and Tapawai ONFL and ONCs. So I stand by the recommendation in my section 42A report to include mikitahi. This is supported by the following factors. The assessment from Mr. Richard Bain, which was not challenged by Port Taranaki and was supported by Ms. Mako. The strong cultural evidence, including waiata and photos presented by Ngāti Tawiti, that mikitahi is part of the Ngāmutu Islands cultural landscape and should be given the same recognition in the PDP as the other members of this group. Evidence provided by Ms. Mako that the SATHMS rules only look at the cultural values of an individual site and they fail to protect and recognise the importance of mikitahi as part of a wider cultural landscape. Are there any questions on that?
I have some questions, but I think we'll particularly Ms. Well, for you both, but we'll start with the normal order for with Commissioner Coffin.
No, I didn't have any questions at this moment.
Commissioner Littlejohn,
Nor I.
Commissioner McMahon, you're on mute, buddy.
Yeah, sorry, my mouse was playing up, couldn't unmute myself. Just one question of clarification, and Ms. Young, you've outlined the situation with the SASM. What's the situation with the archaeological overlay rule? How does that relate to Mikatahi?
Oh, I haven't looked at that rule. Can I can look at that rule in my right of reply.
Yes, the only reason I asked that is that the Port Taranaki response was it was both the SASM and the archaeological overlay that provided protection in their view.
Do you, just point of clarification, do you also want me to look at, because it is an archaeological site, so it will be covered by the heritage, kind of the heritage, do you want me to look at both issues?
I don't need you to do that. I understand the archaeological authority protocols quite intimately, but whether the other members of the panel do.
Okay.
The focus is really on what the plan provides in relation to archaeological matters.
I can do that. Yeah.
I for one would be interested in any information in terms of its archaeological site information. Have we had those presented to us? Because there will be I presume a report, and
Can I just clarify that?
yes.
So in preparing and looking at these submissions, we do have historians that work within the council,
Yes.
and I did also talk to Miss Ritchie, who's
Yes.
and I did look at, I mean, I noticed that I knew that it was a SASM site and the archaeological. So I didn't ask for the archaeological. I knew that was well established.
The record itself.
The records.
Okay.
So I didn't look so much at that because it's actually listed as it's one of the first. It's archaeological site number 3.
Yes.
In our plan. So it's been listed and accepted as an archaeological site. And I thought that those matters had been dealt with, but I can provide that information.
Look, I can find them myself because it's probably more of a personal interest of mine about the reasons, the record of what the archaeological site is. Is it just a par? Are there other features? That sort of information is what I'm particularly interested in.
I did note that I did look at the treaty settlement. I looked at, and it's in the cultural redress. There's a statement about Mokatahi, and it may be more information we could get maybe from Te Arawhiri. There would have been quite a substantial historic account that would have supported that statement of cultural association.
Certainly for me, in relation to the question of outstandingness and the case law that I think one of the commissioners touched on about needing to be truly special, iconic, those sorts of factors, the history to me and the reason for the record and the archaeological record as it relates to that place, I think is relevant to me. So if you could just provide a summary of that would be certainly helpful for me. Okay. So David, you've got another question there?
Well, just on that, I mean, the response from Ms. Young is that she's relying on the evidence of Mr. Bain, that's uncontested. She's also relying on the cultural evidences, and she's responded to the first point that Port Taranaki raised, and that is, in their view, the SASM provides protection. She disagrees with that, and I understand the rationale. The second point of Port Taranaki was that there is protection in the plan because of some listing in relation to archaeological, and I just want to know what the policies and rules around that is. I understand what the Heritage New Zealand procedure is, and I don't need to know about that. I need to know what the plan does, and so that I can test the claim from Port Taranaki that the SASM and the archaeological listing in the plan is sufficient. So it's a factual analysis of what the archaeological rules in the plan are. I just don't know what they are.
So that's a planning assessment, which I think Ms. Young's nodding her head.
Yes,
My information request is more about the values,
Yep.
I suppose, which come into our wider decision.
Yes, you've got the benefits here of seeing Ms. Young, I don't.
Yes. So
And there you go.
Can you see
Hi.
Ms. Young? Yeah.
Good morning.
Okay.
That's a much better picture, Stephen, I've got to say.
I'm glad you've said that. Because I agree. Now look, I do have a question about the information resource from a landscape perspective for our decision making. I must say how hard I should pitch this. I suppose I'm astounded that there hasn't been the landscape assessments for Africa around this area done by either the regional council or the New Plymouth District Council. I know there was one done that we talked about, Ms. Young, that was prepared by Taranaki Regional Council, but only by staff, not by landscape architects. And it did have some peer review, but just enlighten me. Other regions and districts do these regularly and also have them peer reviewed and updated. So just a sense of, because of the special character of those particular, the Maunga and the Ngāmotu, I suppose just some information for me about that.
I think in the section 32A report for the landscape, natural character and landscape, it does list all the previous landscape studies.
Yep.
So they were done to support our first plan, which I think they were done in the mid 1990s. I don't know if Richard, you've got more.
Yes, there was LA4, Mary Buckland. She undertook a study for the current plan.
Yes.
And then there's been no further comprehensive landscape assessment of our district, except for the 2015 TRC one that you referred to.
Yes.
Which is coastal, of course.
Yes.
And in response to your question, it seems sort of remarkable that these haven't been done. I agree. I think in a way that the Maunga and the Sugarloaf Islands have just rolled on. That they've been assumed to be important, have just rolled on without question.
Yes.
And Mikatahi has been a little detached part that's been just omitted, really.
Okay. Look, maybe that's the answer, that they're so obvious that there hasn't been a need. But I suppose my query goes back to the evolution of ONFL practice through a number of these key court processes, Pigeon Bay case and development of the Pigeon Bay criteria, and then there's been some further recent evolution about assessment criteria that's, I think, the Landscape Architects Institute's been developing and agreeing on. So the fact is that we have what we have. We have one expert landscape architect giving us evidence, and we will look at that. We also have the strong cultural evidence, which when I went through section 15 of the NZCPS, I remember we did that through the planner for the port, and I think she agreed that those key contributions to outstandingness come via the landscape elements, some ecology, which of course landscape architects do pick up on their assessment criteria, and certainly the cultural associations are very strongly outlined in that policy 15. So yeah, that was really my question, just to double check what had happened. So there was one prepared by Mary Buckland, 1995. Landscapes don't change that quickly, so we can rely on that. And apologies, I should have picked it up in the 32A report, but that's good information. Thank you. Carry on.
Should I just move on? I just wanted to acknowledge the submission by Jamie Tuta relating to the settlement process for Taranaki Maunga. It's really just to thank him for sharing that information. And I think it while he recognised that the transfer of powers under section 33, which Taranaki iwi had a number of groups had asked for in relation to the land use functions that the council has, is outside of the scope. I thought that his submission really reinforced the cultural importance of Taranaki Maunga within our district landscape, and I just wanted to acknowledge that. The other matter was raised is around the inclusion of Pukeiti, which, as you've discussed earlier today, is really reliant on legal advice, so I won't speak to that. But I will respond to it once I've got the advice in my written report, in my written review.
So do you have any reflections on the position from Taranaki Regional interim views on the submissions from Taranaki Regional Council and also the trust? Can't remember the name of the trust.
The Rhododendron Trust?
No, the private trust who presented to us saying that they've got management plans and agreements about how they look after their own land.
Is it the Katikara one?
Yes, yes.
In the SNA.
Yes.
Yeah.
Oh, that's an SNA one rather than ONFL. Sorry, gotcha. Yep. But in both. Okay. So I think the pitch there was that we've got everything under control, everything we need in our own management processes. So do you have any initial thoughts on that?
I just, because it came up through a further submission, I didn't turn my mind to it because I thought it was out of scope, but I need to confirm that with, you've asked me to get legal advice to confirm that.
Yes.
I suppose in terms of, what they're asking, it was quite similar to Mikatahi.
Yes.
In terms of, I have to see whether it would meet the assessment criteria in the policy of the plan. So I'm unsure whether how something is managed is included in that policy.
Okay. Any other questions on that point, panel? Nope. Carry on.
The next issue was around the exemption for network utilities in rural NFL R3 and NFL R11. Evidence presented by Ms. Para on behalf of Kaitahu or Taranaki Trust request that the permitted activity status for the network utilities is removed. However, I favour the evidence of Mr. Wood, who presented on behalf of First Gas. I thought his evidence was really clear that there is an operational need sometimes to get immediate access. And in his case, it was to the gas pipeline so they could undertake repairs or maintenance. So again, I stand by the approach in my section 42A report, which was not to make that change.
Thank you.
And the last, are there any questions on that?
No, I think we're good. Thank you.
The last submission was the submission from Transpower. I note the concerns raised by Transpower in relation to the changing nature and extent and location of the national grid within the New Plymouth district. But I stand by my recommendation in my section 42A report not to include any specific reference to the national grid in the natural features and landscape chapters, and agree with Ms. Raitt that these matters are best addressed in the network utility chapter.
Thank you.
And that's the end of my verbal report back.
Thank you for that. I'm sensing that there are no other questions on that topic. So we'll just carry on with the next subject. Thanks, Ms. Young.
As Ms. Davies is here, I'll do public access next.
Yes.
So Ms. Davies also, she presented the expert evidence. We've got a few slides to show as well, but I'm just going to, first of all, I'm going to, again, it's for conciseness. I've just looked at the main issues. So first of all, I'm just going to address the many questions that commissioners asked on day 2 of the hearing. So Commissioner Dace requested that the council provide information as to whether the 20 packs, so there were the public access corridors identified in the PDPs, remember they're shown on the little dashed green lines or up above there, are able to be physically formed. I've discussed this matter with Ms. Davies and she will review, it's quite a big exercise. She needs to review the evidence that was used to compile the packs, including records of site visits, and she will apply a written reply, a written statement, which I'll include in my written right of reply. Commissioner Dace, you also requested that the council analyse the risk to the council of not notifying a landowner who owns a property which contains a pack. I noted in my section 42A report that we didn't send letters out to landowners that had a pack going through their property. I'm yet to analyse the risk and I just need more time. I need to get to do a GIS join to understand how many landowners are potentially affected. I would like to ask a point of clarification though, if that's all right. I was just wondering if you were concerned because the council, it's sort of interesting because the packs relate to access that has been formed. So those landowners would be well aware if they've subdivided their land that it's either in a reserve, so it's no longer part of their land, or they have a strip. Okay. So is your concern really about the incidents sort of on this, if you look on the slide behind you,
yes,
or is it in front of you?
Yes.
Is it about the properties where it hasn't been formed?
Yes, yes,
okay, right.
Yes, it is. It's those properties which are probably gaps in the current formed, and yeah, just
okay.
Just the question about having some a notation on the plan indicating that something's coming, which may not be that appreciated in terms of any any issues or process issues in terms of notification, or real issues around, you know, what sort of effects that might have on those landowners.
Okay, again, that's great. I'll work with the relevant council staff and provide a response in my written writing reply.
Thank you.
Stephen,
Yes.
so Anton and I have a couple of questions on that.
Okay, I can't see at the moment, so you just do button. Yep.
Okay. I guess for me, it would be the notification issue on proposed packs might benefit from some legal advice from Ms. Wallace.
Okay.
And Commissioner Coffin.
Yeah, I was just reflecting on one of the questions I'd asked during this part of the hearing was about whether those proposed or indicative packs should be in the plan or could be outside the plan. It was a question about what would be the most effective and efficient way of doing that. But thanks for the clarification regards the difference with those which have been formed and those which haven't. That's clear. Thank you.
Can I just go to, because Commissioner Coffin raised a really great question around whether we could differentiate the spatial layers. So I put a slide up. So I talked to Ms. Davies and Mr. Lobb, and it was actually quite a relatively easy process. I might get Ms. Davies to explain it.
Sure. Thank you, Ms. Davies.
Through the panel. So we already have an existing layer in the council's GIS system that has the existing formed pathways within reserves. And we also have a layer that shows the existing esplanade strips. So the slide in front of you shows a little snip example of a location where there's the 3 different scenarios that might be within a pack. You'll see that, and what we're proposing is that it would be a relatively simple exercise, albeit some time involved, to identify with a solid green line the existing walkways within existing reserves, a dotted green line for proposed, so filling in the gaps and extending the packs, and I'll refer to a little bit more detail that differentiation later, and the pink solid line for existing esplanade strips that are in place. And that would potentially address the concern that was raised by a number of submitters around the public accessing this pack layer and understanding clearly what is publicly accessible currently and what isn't. And I guess thinking forward that it might be a similar scenario as the SNAs, where every 5 or so years during the period of the proposed or the district plan, there would be an update for to update with any that had been acquired during that period, because it wouldn't be able to be regularly kept alive, I guess. So that was just some preliminary thinking that we'd put into this over the last day.
Can I just butt in there? I know, Ms. Davies, you did say you were going to get to it, but I'm always a bit of a spoiler and like to get there quicker. I mean, to me, that's fantastic that you've been able to identify that, because it then leads itself to potentially clarifying the rules to quite a useful extent. And I mean, for example, you could differentiate in the rules then between existing public access corridors and proposed public access corridors. And so then you'd have the rules which regulate activities on existing public access corridors would be different from those rules that you're trying to regulate conduct adjacent to the corridors. And I think part of my confusion was you've used the word within within the rules in two different senses. So, you know, some of your rules are you can do this or you can't do this within an access corridor, which only really makes sense when you've got a physically identifiable and defined width to the corridor. But then you've got other rules which regulate activities within 50 meters of, which makes more sense when you've identified, for example, a proposed access corridor. The rule then says, well, if you're going to do something, you shouldn't do it within 50, i.e. there should be a setback from the corridor, which to that extent makes that clarification very clear, and also clearly identifies that the activities that you are contemplating being able to occur within acquired and formed public access ways are very different from those that are just aspirational corridors. So I think that's a really good start to sort of think about clarifying how this chapter and how this layer might work.
I did just following up on your point, Commissioner Littlejohn, I did notice that we are, I mean, in terms of the formed corridors, it would, like with the natural features and landscapes, the ONFLs and the ONCs, they're shown as polygons. So it's quite easy to tell if you're within them. So I think the next stage of this work, we were going to sit down and see with the formed, especially the reserves, whether we could show them as polygons. But again, that comes down to how accurate the data is and what it would actually do to our E-plan, how messy it would make it look. Lines look really nice on an E-plan, but once you start getting polygons, it starts getting quite busy. So we don't want to destroy the readability of our plans. So
yep.
Yeah.
I think you potentially get into trouble doing that with the proposed access corridors potentially, because you're then sort of defining what might be the future potential esplanade, reserve or strip without any real ground truthing of whether that's appropriate or not. You might also have a notification issue if, for example, your polygon extends further onto private land than the extent of the current dashed green line. But I guess those are things you guys have clearly got your heads around and are thinking through.
No, I thought I was just talking about the formed ones because.
Oh, okay. All right. Sorry.
It's in the council record as to how wide the reserve is or the
Gotcha.
strip is. So no.
So wouldn't they show up in the cadastral layer that's showing the land parcels to some extent?
Through the panel, yes, they do.
Because we're assuming that all of those that are formed have been taken, are comprised in a certificate of title or a register, and are in council or other sort of ownership, or are subject to an esplanade strip, presumably, which is also defined.
That's correct.
Yeah. Okay. All right. Yeah. Okay. Thank you, Mr. Commissioner. That's really helpful.
And Mr. Coffin, just any follow-up from you? It was your...
Yeah, no, that was really helpful. That's a really good start. That makes a lot of sense. Thank you.
Okay. And I think we will need to have a talk about timeframes for reporting back, because I think this work should be reported back to close this hearing and the right of reply. So we are open to your suggestions about the amount of time, because I know that these processes, we have a good idea. They do mean bums on seats and time and reality. So you should probably tell us what's a reasonable time frame, because I do want to be, as I say, close the hearing, have all this locked down and the right of reply.
Can I? It's just that the GIS analyst has raised some issues around the quality of the data.
Yes.
So if we could have maybe 3 weeks, it's quite a big scheme change.
It is, yes.
So 2 weeks is, 3 weeks.
So that could line up with, you know, a report back, target report back date, which you could give us. It's better if you come back to us on that, because of, you know, this is a big topic. If you need, is it 3 weeks from today? Is that reasonable?
3 weeks from Monday.
Friday? No, Monday. 3 weeks from Monday, whatever that, maybe we should just recall what that date is now for the record, so we've got it clear.
Stephen, just to add to that, I think the position of Ms Wallace on this is going to be critical,
Okay.
Yes.
particularly hearing the answers to Commissioner Littlejohn's questions about the extent to which the rules associated with both the proposed and the existing PACs impinge on private property. So in a way, there's a quasi designation issue here. And I think it's going to be critical that we understand Ms Wallace's advice on that from a legal perspective.
And that could form part of the right of reply, David?
Yes, it would. But if it raises a procedural irregularity, that's something that the panel will need to deal with in terms of notification.
So are we suggesting a two-stage approach?
Not necessarily, but I think it would be useful if reporting officers had Ms Wallace's advice in advance of them finalising their position.
Oh, yes,
Yeah.
I understand that. So, the three weeks seems to be time enough to gain that as well.
Yes,
What's,
I hadn't appreciated that there were rules associated with the PACs in terms of within 50 metres of the corridor, etc. So that's my own ignorance. Apologies. But given that, I think that's going to be an important consideration for Ms Wallace.
Kit, you got some thoughts there?
Oh, look, it's really just yeah, I think it's something we probably need to discuss amongst ourselves. But well, look, let's get it out there, because if we were all in the same place, we could get into a bit of a huddle, but we can't. So we're going to have to do this publicly, I guess. All of the green lines were identified and notified, as far as I can tell. So I wonder what the legal issue is. That's all. I'm just.
Yes, if the green line was a designation and it inhibits property rights, and it's not a designation, but it's a line that has rules that go beyond the line and could impinge on private property, then I think the issue is, should the private property owners in which those rules impinge on have been directly notified in the same way that a designation would have been notified on them. And that was an issue. That was an issue in the designations hearing that we had as part of hearing 3.
Well, if it applies in this instance, then it also applies in a variety of other chapters too, David, because there are, for example, the setbacks adjacent to water bodies. That's another one where there is an impingement on private rights. But so is this an issue around the obligation to directly notify a landowner if there is an imposition by way of rules in the district plan on their rights? If you took that to its logical extent, then every landowner ought to be directly notified rather than just a public notification process.
Yeah, that is the issue. I don't know how far it extends, Kit, but all I could do is draw the analogy with the designation.
Yeah, I think the issue there is I don't think there's any law which says a council's not able to put indicative lines in its plans, and in this instance, any sort of compensation is, because these things won't get taken without a process that's involved under the Esplanade provisions of the Act, where compensation is provided for. But anyway, look, that's a completely different issue. So
The issue is whether the rules would, had landowners known that there were rules that could impinge on what they can do on their property as a result of the indicative lines, would they have submitted an opposition? And that's something for Ms Wallace to tell us.
Yeah, it only applies to quarries or in the general industrial, port or major facility zones. Yeah, anyway, look, that's something that we should probably get some advice on. Yeah.
Yes, thank you.
So I'm just going to move on. The next issue that was raised in submissions was the White Cliffs walkway. And again, I've discussed the matter with having heard the submission of Mr. O'Carroll, who presented on behalf of Mr. Dixon, and also having read the evidence tabled by the New Zealand Walking Access Commission. I've discussed with Ms. Davies, and she's got some slides about possibly showing the formed part of the walkway. See the
Thank you.
Through the panel, just in terms of that, I'll just introduce that a little bit in the sense that one of the questions raised by Commissioner Littlejohn was around for me to look at the current range of packs, what's included and not, and sort of some thoughts around why things aren't included. So just as a brief introduction, and then I can talk about the specifics of White Cliffs walkway as a case study.
Yes.
So just in terms of providing some clarification on whether packs should or should not be included, and ensuring in particular consistency around our approach to whether a pack is to be included or not. Having given that some consideration, I can confirm that the 20 identified packs in the PDP all highlight areas where we have strategically identified a formal walkway opportunity or a shared path opportunity. And I think that's a key distinguishing point, is that the packs are around at a high level identifying formalised pathways and access ways, whereas some of the access provisions within esplanades and esplanade strips are more around general access that may or may not have formed pathways. And I think that's a useful, potentially a useful distinction. They're often about filling in the gaps in a current walkway route that council has, or and or extending a walkway from a strategic perspective. So the identified packs are all strategically achievable. We have done some ground truthing, not in-depth detail, but there has been walks on site. It hasn't just all been completely desktop. The criteria for inclusion of a pack that is there has potential for achievement over time, either through subdivision, acquisition, negotiation, and as a very last resort, a designation process. And I think I outlined that in my evidence in terms of that process, preferred process that we take. And there are some packs that we have not included specifically. Again, I think I touched on this in my evidence. And they were specifically not included because we didn't want a potential to include anything where a potential route had not been specifically determined. And an example of that is the Waitara to Bell Block walkway, which is an extension of the existing coastal walkway. So although that's identified as a strategic project and a public access project, at the time the plan was notified, we hadn't done the work to confirm what route or corridor that might take. So therefore we felt it wasn't appropriate to include it because there was that lack of clarity. And I guess in my view, that's where the White Cliffs walkway sits as a sort of a similar example to that, where in this instance, it's the complicating site and land ownership situations that mean identifying part of the walkway as a pack would be preemptive of what would be a very complex and long route negotiation, which also might include legal requirements. And so in order to highlight that, some more detailed background to efforts made to date might be important for the panel to understand, and I can provide you with quite a lot of detail around that if necessary. But in summary, that over a period of years, both Council, Department of Conservation and the Walking Access Commission have attempted negotiations to try and achieve that, the very northern extent of the route, which is the piece that is along the paper road, which is the connection, without success. And we've even attempted to use the Public Works Act as well, and that has been without success to date. So I just, I've got details of that if necessary, but I guess it just highlights the fact that it is a complicated PAC scenario. In light of that, however, and this image above shows that the current walkway, of which follows the route of the pipeline, and that is included in Ngāti Tama land as well, is still an extensive walkway. And if the intention to recognise the importance of this part of the landscape and this walkway was desired to be shown, then I don't see any reason we couldn't identify the existing walkway as a PAC to recognise the importance of this. I guess my point is that it's the connector point that is the one that is more contentious and not able to be confirmed at this stage. There's some other images I'll talk you through. So that is a courtesy of Google Earth, an image that shows the existing, so there's 4 parts to the walkway. There's the Pukearohei to Waipingau stream, which is a 6.5 kilometre, 3 to 4 hour walk. And that is the red line identified there that goes from the car park at one end. And you can either go back the same way or you can walk along at low tide along the beach. And that provides access to those dramatic white cliff landscapes in that scenario. And that's actually an evidence from the past has shown that that has actually been the most used walkway in the range, the others. Just to the side of the screen where the White Cliffs label is where the stock tunnel portion goes. So from Pukearohei to the Te Horo stock tunnel extends it to about a 22 kilometre walk. And that's the portion where the current safety issues around the stock tunnel have meant that portion has been, or the stock tunnel is closed to a certain extent. As mentioned by submitters, you can actually get through there, but there are safety concerns around that, so we don't recommend it. And then the next...
Sorry, just to clarify 2 questions. That car park at the Pukearohei,
yes,
that's quite small and constrained, isn't it? Or I remember driving out there once in the Mount Messenger hearing just to get my head around all these issues, because these were part of looking at routes and things. But is that my recollection? Is that right?
That's correct. It's a small car park area, and I guess it's reflective of the amount of use that this walkway, and we haven't got current data, but the data up to 2018, over the whole year, when the whole walkway was open, there's usually about 2,500 people in total over the summer, including the main summer period, which is the busiest period that utilise the walkway. So it's not, it's used and it's popular, but it's not the type of numbers that we're seeing in some of the other council walkways.
Okay, but the Te Horo stock tunnel's not on this plan, is it?
No, it's outside of that image.
Up the beach.
If you go to the next image, I can show you.
Just before you do, Renee, the line that goes inland there.
Yes.
Is, I mean, that's the route you'd have to take if the tide was high or you didn't have a wetsuit, presumably. Is that publicly protected, or is that by dint or permission of the landowner, that one there?
Through the panel, that is, I believe, is publicly protected. It's through private land, it's through the Ngāti Tama land, but it follows the route of the, as I understand it, it follows the route of the pipeline that was put in, which is what makes it accessible, and that is managed by Department of Conservation. And I'm not sure what level of protection there is on that in terms of a walkway.
Okay. Presumably there's a point right at the northern end where you come down the valleys back down to the beach that is not the pipeline route.
That's correct, and that's where it's a relationship, a long-standing relationship between DOC and Ngāti Tama, and it's related to the restoration work as well that's occurring in that whole block that was outlined by the submitter.
All right, no, thank you for clarifying that.
The next image just shows it's useful because you can see the paper road that runs through the farmland. So that's what we're calling the northern portion, and you can see at the lower end of the image. What's the township? Tongapurutu, sorry, my mind blank there. See Tongapurutu. So it just gives you an understanding that the northern portion that we're talking about, and you can see the coastal erosion along the cliffs there, that towards the north end is where the erosions occurred and taken out the paper road. That it's quite a different landscape. It's flat farmland. It's actively farmed. When it was open, there were arrangements that it was closed during lambing season, all of those sorts of things. So I just thought that was useful for context.
So this is Mr. Gibbs' land?
That's correct.
All that big farm there, is that his property?
I haven't checked whether all of it is, but certainly a large portion is my understanding.
Okay, thank you.
Yeah. Oh, that's not, yeah.
Thank you, Renee. That's really, really helpful. As I said, I think we did fly over some of the panel when we did our tour, but I've had an extensive helicopter around here, but this image in particular here is, and our previous one is super, super useful.
Right.
Any other questions for Renee on this matter, the White Cliffs Walkway?
I guess I'm just interested if two issues. One, if we came to the view that we liked the idea of the plan showing an access corridor here through private land, i.e. Mr. Gibbs' land, do you think we've got scope within submissions to do that?
There were, I think, 30 submissions, original submissions that asked for this. I suppose the issue is really, and I might put it out to Ms. Davies, it's just that the council has made a decision on some funding, but it's not. Can you speak to that, Renee?
So through the panel, so as outlined a little bit earlier, there's been extensive work to try and achieve that northern connection without success and at cost. And to resolve the issues, there's a significant amount of work and cost involved. And so council has identified to explore that in more detail, but it's not seen as a high priority because of the numbers of users and the fact that there is an existing walking track still within that landscape. So I think it's year 10 of the long-term plan. They've put some budget in there to do some of the feasibility work and to re-enter into, I guess, range of negotiations. And I think there's about 6 different options that could be explored to resolve this. Some of which actually look at just doing extended loop walks to the Tohoro stock tunnel and upgrading that rather than necessarily doing the whole connection. So I guess that's where that view that I've outlined in terms of my opinion around the preemptiveness of that, because it might be that there's a range of different scenarios that might result that might not necessarily, was showing the green dotted line align with that. If that's helpful.
Some extent,
yep.
Just to some extent, the designation of a PAC in the district plan does little more than indicate that the landowner should be wary of 2 things. One, that if they are going to do any building activity, then it needs to be set back a distance from that corridor. And it also does another thing. It would, if they subdivide, trigger an ability for a requirement effectively to give an esplanade reserve. And just thinking that through to that extent, if the land has eroded and mean high water springs is defined not by survey but by the location of the mean high water springs, then presumably if Mr. Gibbs subdivides, he's potentially going to be up to give a 20-metre esplanade reserve anyway. Is that am I right in that regard? So we don't, to some extent, need to worry about that?
Through the panel, that's my understanding. And I guess the complicating factor with that is that an esplanade reserve doesn't move with change in the landscape. And that particular coastline is so prone to erosion at quite dramatic levels, you know, up to 1 metre a year sort of thing, that even if we took esplanade reserve, we'd have to allow for quite a large extent of that, or we might end up with the same situation as we've got now, where the paper road has disappeared.
I know you can make provision and identify, for example, you could say you want a 50-metre esplanade reserve if that property is subdivided, but you've then got to pay the owner for the top up over the 20 metres. But again, it all comes down to whether the land is subdivisible and whether I'm just sort of thinking if there's a trigger there that that does that. But
I think that's probably I think
as far as we can take it.
Yeah, as far as we can take it. And I think when you use the term designation of a PAC, I think that's probably. Were you thinking about formal notification of a requirement or just the placing of a aspirational dotted line on Kit?
Oh, I'm talking the aspirational dotted line.
Yeah.
Obviously, if in the I mean, there are 3 ways councils, 3 ways local authorities can get land. One is through negotiation. One is through if a landowner is obliged to give it to them if they subdivide. And the other is by way of designation and then using the compulsory acquisition powers. So,
yes.
And that's obviously a completely separate route if they want to go down there. And I accept Ms. Davies' evidence that even if they were to do that, they don't have the resourcing at the current stage to put into it. So it's very low priority, which I can completely, appreciate.
So the evidence we have from the council, I think, is that even the aspirational dotted line in this area is not recommended because of the processes and the timing issues. I think, Renee, that's the summary.
Through the panel, yes, that's right. I think, if it's helpful, that what we're calling that northern connector, between 2012 and 2018, there's an estimate, there's approximately 430 people use that, because you have to have 2 cars, one at either end, to be able to, because it's such a massive walk. It's like a full day, if not more. So So that's where the low priority came in, and the focus around the existing southern end, which is a loop connection, and potentially looking at that, and the Tohoro Stock Tunnel would be probably more likely where it might end up.
Can you go back 2 slides, Julie, and just that little, those red marks at the top near Tonga Perutu, are those existing walkways people can do in and around the northern part?
Through the panel, yes. So there's existing road, semi-formed road and paper roads that are accessible at that end.
Yes.
So that's sort of this image just tried to show the 2 portions at both ends that are accessible currently
So
and open.
You think you could show both of those as available in the solid green line in your plan?
Yeah, through you, sir. I felt that it might go some way to responding to the desire for the importance of this landscape and access to it to be documented in the plan, without raising the expectation around a connection between.
Okay, thank you.
Shall I move on to the next matter?
So your next matter is waterways?
No, it's just there was the next matter that was raised in this hearing was about a policy to exclude public access.
Okay. I'm thinking it's perhaps time for a cup of tea, but I'll also signal that we do have Juliet Johnson and Sarah Edwards here, and the panel does have a procedural matter we'd like to discuss with the wider and with 2 other experienced planners just before we do break, and just take advantage of the fact that you're all here, because we were going to raise it as well. It's really about, this is off topic, this is general. It's really reflecting on the value that we are getting from the Section 42A officers, and a bit of a change that sort of occurred just by default. I think that originally we'd said in the procedures that the first part of the hearing would just be quite a brief mechanical, you setting out the way the rules work and the policies work, and just a bit of a roadmap. Then we'd hear the submitters and we'd have a very detailed discussion at the end. I think what's evolved, particularly with this large hearing, the thematic issues that we wanted to explore, we were much more thorough on that with yourselves and also the witnesses at the start. Whereas this is at the end, when we're just summing up, it's just really letting us know what your thinking is before you write a reply. We're finding that most helpful. And I've just sort of, I wanted to raise that formally with the council team, because that does alter expectations, and certainly how you organise, you know, who's here at the start, and in terms of witnesses and those sorts of things. So that has been an evolution. And I would like to say that we did discuss this morning. We're finding a lot of value from perhaps the broad, we think it'd be different in different hearings, but with this large one, we were coming in a lot of evidence, the fact that the staff have been looking at these issues for a number of years, just massive amount of information that you can relay to us before we get into the details of submissions. We found that most helpful. So I just really, just some feedback on that. I don't think we need to change the procedures formally, but as a matter of practice, just signaling that that's what we're finding most value in. And just in any of you, happy to hear back from you now. Sarah, if you'd like to come up to the microphone.
I've actually felt that it is very useful too. And in my review work, I'm of course a good 6 weeks ahead of what's going through. So where we're at now. So as I've been reviewing in the zone chapters, I've noticed in our template that we've been using, there actually needs that opportunity to set the scene. So it's become very apparent to me in the work as well, and actually describing that, because having it up front also is quite efficient in that we don't need to keep repeating that in a written sense in responding to submissions as we go through. So so I've noticed that coming through in the zones as well, but also in preparation for this particular hearing, particularly around our journey with the SNAs, we were very mindful that what has happened in Taranaki may not be reflective of what's happening in other parts of the country. So we felt it was very, very important. So I'm really pleased to hear that you've got value out of it. And it is, you will see, because we've noticed it too, and we've felt we've needed to pivot a little bit to adjust to that. There's another aspect that's come through with your questioning as well, particularly with those higher order documents, which I'll come back to, but particularly with our story, with our zones as well. So you will see a slight variation in the template that we are using with the officer's report to tell that story as well. But what I'm hearing today is that you are finding it useful, so we can make adjustments to how that comes through in the written side of it, but also that some of it can also be said through the verbal side at the start of the hearing as well. So obviously, Michael, you don't need screeds and screeds to read as well. We've also found that through the hearing process, to do with the questionings, particularly around the regional policy statement as well. So that comes, that we've noticed we've needed to respond to a little bit more, and also these higher order documents, and that's been heavily featured in this hearing to date as well. So we've been trying to build some of that commentary into the reports as well, and I can also brief the team on that side of things. Well, I have briefed them, and we've been trying to bring that in, but knowing that you are getting a lot of value out of the verbal side of it, we can factor that in as well.
Yes, and certainly the value for me and the rest of the panel, it's that sort of dialogue we can have, which is what I favour. It's that peer dialogue, where we're actually just learning and finding out about some of the key issues, and just teasing out when we read things. You'll see that there's, we are reading things quite thoroughly, and there's things that prompt us, and having those discussed on a thematic basis at the start with the council planners does just, we get into the zone really quickly, and we found that excellent, and the reporting is we found very, very helpful, and as it's evolved, and certainly things like providing us a copy of the key environment court cases for the SNA stuff, that's just right there, and we can come well prepared. So but I did want to have that discussion in public. There's other people listening in thinking that certainly people have been at the hearing a lot. We'll see a slight shift of what we've done, and that's just evolved out of a natural need for us to obtain that perhaps fuller briefing at the start. And yes, so that's all good. Thank you, and we'll have a cup of tea now, and we'll come back at 11:45. Thank you. Thank you. All right, Ms. Young, I think we're back with you.
Yeah, so just the final matter, and it's come up through the Waterbodies chapter as well. It's around a new policy to exclude public access. It was raised by Trust Power and also by Tangata Whenua. I've sort of reviewed my recommendation, and on the most part, I think it still stands in that if the access is formed, then there is the ability to use the Reserves Act. If the access hasn't been formed, then there's an ability to waive the requirement. And I did note that Ms. Marco and also Ms. Davies are working together to try and develop a more sort of strategic approach to taking esplanade reserves, which is outside of the plan. But I will do some further analysis as to whether there is any particular merit of a policy. I'm a bit concerned that it may have a perverse effect, but maybe there may be some circumstances, but I will do further work on that and report back. And that's the end of the matters for that chapter.
Thank you. I think that's a very good summary. And as you say, if you can just write those brief summary points up, that would be useful. Any questions on that last point, commissioners?
Yeah, I did. Oh,
yeah.
You go, Kit.
Yes, I did. One of the issues I raised was with the in particular rules. Well, all of the rules from R4 up to R7 all refer to the policies as matters of discretion, and I just wondered whether you'd had a chance to have a think through whether the policies were actually going to were crafted in such a way where they were actually usable as matters of discretion, and whether or not you were going to make any sort of further thinking around that and let us know.
I haven't had a chance to do that yet, but I will do that in my written reply.
Okay. All right. Thank you.
David?
Yes, Ms. Young, when you referred to the new policy regarding access, was that in relation to water bodies or in relation to something else?
It came up through the public access submissions, but it does relate to quite a lot of the submissions on policy WBR5, which is the policy to waiver, and I felt that it was talked about in both chapters.
Okay. The reason I asked that is you might recall I had some questions to Ms. Marco last afternoon regarding WBP9, a new policy on public access avoidance policy. I just wanted to make sure we weren't talking about that.
No, but I mean, they are really interrelated.
Yes.
And I thought that your questioning, were you, I don't want to have two policies sitting in both parts of the plan. It
Sure.
would be really confusing. So my analysis will be, if there is a need for a policy, it would be, because I'm the reporting officer on both
Yes.
chapters, I will look at whether it's appropriate. In terms of the, for example, with the trust power, protecting their issues were around protecting the infrastructure, providing health and safety. I was just going to also look at whether the waiver requirements adequately dealt with those matters. So I think there's a range of issues across the two chapters that I'll be looking at before I would suggest. I want to see if there's a gap.
Yes. That's good. It sounds like you're very much alive to it, and thanks for acknowledging those questions yesterday. One of the things I omitted to ask Ms. Marco yesterday was I asked her about looking up to the objective with that new policy and what objectives that policy might give effect to. I omitted to ask her about looking down and what rules might give effect to that avoidance policy. So maybe when in your written reply you could canvass that issue as well.
Sure.
Thank you. Thank you, sir.
Thank you. Moving on to water bodies, I think.
Okay. Again, I'm just going to, at a high level, address questions first in a really high level, and then here we are. And then some high level responses around the concerns from tangata whenua, and then some responses to the other submitters, Trust Power, Land Pro and Greymouth Petroleum. which relate to the exemptions of the rules. Commissioner Dash, you asked me about the origins and purposes of Schedule 9. In short, there was quite a process to develop the schedule, and it has evolved from 25 priority water bodies, and it's now up to sitting around 90. And the Section 32 A report, and I also refer to how it was developed in my Section 42A report. And I just want to state that it does include quite a lot of statutory acknowledgement rivers. So that was the sort of primary, but there was an agreement that it wouldn't include, it would just be the main stems and not the tributaries. And that was agreed by Ngāi Kaitiaki. Some of the things have come in because they were part of the PAC network. So identified through strategic planning outside of the plan. The previous schedule didn't have any lakes, so we put the lakes in. And then the interesting kind of Ngāi Kaitiaki, which is the group of iwi and hapu that informed the plan, also asked for the regional wetlands to be put in. So it's quite an interesting mix, and it evolved over a number of years to respond to. It also, there was consultation with Fish and Game and the Regional Council as well.
Okay.
I can document it fully in my write a reply.
Well, certainly don't do any new work, just signposts where in the 32A and other things, but you know, I was asking those questions about wetlands because some people think they're no man's land where no one's looking after them, but sometimes it's even worse if two authorities are looking at controls, policies, rules that, you know, sometimes apply depending on what the water level is. So that's my, and I suppose it's my interest in that area comes from my practice where those wetland issues are pretty top of mind at the moment for all practitioners and all councils. I'd suspect through the way this MPSFM 2020 has been drafted and is evolving, and there's another discussion document out from the MFE about maybe making some more changes to that due to the outcry from some parts of the community. So that would be useful. Thank you for that, Denise.
Okay, moving on to Commissioner Coffin asked me to review both the surface of water activities on the surface of water chapter and the Waterbodies chapter as to whether there are any provisions that I thought were outside of our scope under Section 31 of the RMA. I have reviewed all the objectives and policies and rules in the activity on the surface of water. It doesn't mention water quality, it really sticks to the knitting in terms of, so that I did note in the Waterbodies chapter that I have recommended the removal of in policy WBP5, which talked about that we would identify and map and schedule significant water bodies for the reasons of the importance of water quality. And in my Section 42A, I recommended that be deleted, and also the column in the Schedule 9, which talked about water quality, that be deleted. I didn't find any other provisions that I thought were outside of our scope. And I'll provide that written analysis in my verbal writer reply.
In your written right?
Yeah, sorry,
Yeah.
my written writer reply, sorry. Yeah. Are there any questions on that? No.
Thank you. None from me. That's really helpful. Thank you.
Carry on, I think.
The other one was the question from Commissioner Littlejohn about a great question about the relationship between the building setback rules and the requirements under sub S9, which is the requirements to take the Esplanade, the setback distances for Esplanade reserves on subdivision of land. I did find there was some anomalies, especially it was to do with sub S91 requires a setback of 20 metres, but the building setback, and this is just in the rural zone, but the building setback in the rural zone is only 10 metres. So there is a possibility that, and I talked to our consents team, they said that the incidence of this happening where someone puts a building within 10 metres and then applies for a subdivision, it does occur, but it hasn't occurred very often. But I will do further analysis to see whether it's something, for consistency's sake, they should be the same. And I just briefly this morning looked at how other plans deal with this matter. I looked at the proposed Porirua plan and looked to see that their setbacks were actually the same as their Esplanade reserve requirements. So I think it's a matter that I will definitely, now that you've alerted me to the issue, it is something that I need to think about more. Also, just alert commissioners that this is a live issue with these quite a lot of submissions that have been received on sub S9. And it's a matter I've been discussing with Ms. Lawrenson, and you might know, remember that I did defer my submissions about subdivision around these matters. So it is a misalignment, a potential misalignment. So it is something that we do need to resolve.
I see Ms. Lawrenson's listening in. Nicola, hello. We did have that wider question about subdivision matters across the plan, which I suggest we take at the end of the session today.
I have got that within my
Your
minutes to
scope.
talk to.
Okay, thank you. Carry on, I think.
Going to respond really at a high level to the broad themes that were addressed by Tangata Whenua, and I just really wanted to say that to thank them for especially the some of the submissions that sort of the amount of work. I suppose it was Tapohi Campbell who gave us that great sort of explanation of the creation story and the whakapapa of the why. And that has really turned my mind to thinking about how then I can kind of use that. And I think there was a great statement by Anaru Marshall from Ngāti Maru, and he just put it so simply. He just said, put the river at the centre and then work back from there. So that's my frame of mind. So I'm going to turn my mind to the submissions from Tangata Whenua and then look at the submissions and see whether I need to how I can make some amendments, especially to those land use rules, the setback rules. I am quite concerned though around the use of the term water bodies. I want to be really careful, and I want to do some really careful analysis around that, because it does bring in a lot of water bodies, aquifers, wetlands, ponds, which could have, I don't know how we would control them. It's not our function to control groundwater. So I just want to be really mindful of how I do that. And I just wanted to signal that I am considering those things. And then again, it's around the purpose of section 9, schedule 9, is it to just direct the Esplanade, taking of Esplanade reserves, or is it wider? So I just need some more time to look at that. But I just wanted to say kind of where my direction of travel is. It's helpful. Yeah.
A couple of thoughts from me just on that, Denise. Certainly the work that the iwi submitters have put into their submissions, which gives us opportunity and scope to consider these matters, does provide an excellent sort of launching pad for the plan to sort of consider these matters, and the fact that we've had such an incredible attendance from both senior managers, senior kaumatuas, planning experts from the iwi. It's been, for us as a panel, it's been a real privilege to listen to those special people and just feel some, really to confirm what we're seeing on paper is actually real in terms of just how things are thought about by tangata whenua. So I reflect your comments there. I do think these interface issues with the regional council are critical for you as well in this water body space. It goes without saying. And again, appreciate that TRC and Chris, I think you're online as well. Some of your staff attended the hearing as well. I thought that was awesome. And just working together on these interface issues are really important. So certainly if you need to bounce off, obviously in your right reply, you've got to be in scope, the regional council team, just to work up your thinking a bit more, Denise. I think that would add value as well. So any questions, commissioners, on those matters? There was a sigh. Is that a question?
Oh, no, this is I echo your sentiment, Ms. Young, around the importance of water bodies for tangata whenua and how we sort of address that within a plan framework. And I guess, what do you think of this notion of ditching Schedule 9 and just relying on a definition of water bodies generally? I guess the reason I ask is because Schedule 9 itself starts with the phrase, this schedule lists the water bodies in the district that are identified according to the policy, the criteria in P1. And then P1 is the identify, map and schedule water bodies if they have some of the sort of criteria. So it's the equivalent in the water body space, for example, of policy Eco P1 in terms of identifying significant natural vegetation. And I guess the first question I have, I was just about to bring it up, is there a give effect to obligation in the NPS freshwater that requires local authorities to map and specifically identify all water bodies within their boundaries?
No, my understanding is that it uses, the regional council have to identify freshwater management units, and they have to identify all the values within those units. But that doesn't mean that they have to identify every single river and stream. And it's really around the freshwater management units, having 18 months doing this for Greater Wellington, really around the like for like. So they're big units.
Yeah.
And so I suppose in terms of some of the things I talked about in my section 42A, is that maybe that process, like I feel like scheduling was something that we did to protect things, like it's a really good mechanism, but maybe now that we've got the freshwater management units, the scheduling has sort of been superseded in a way, and that we, with water bodies, you really need to look at the whole catchment. And so and then within Taranaki, it's not really just one catchment. It could be, because there's 230 parent, I think there's 230 parent catchments, 500, that you need to chunk them up into bigger lots than that. And so that's where the sort of real challenges and I don't know if I answered your question, but
Oh no, look, I think it's ripe for consideration in a way, because, for example, I mean, I understood Schedule 9 has two functions. One, by reference to Rule W6, that's where sub S9 is engaged, which is the Esplanade Reserve or strip requirement. So if you're on the schedule, then you're ripe for consideration for an Esplanade strip or reserve to be set aside if the land adjacent to you is subdivided. And then the only other reason appears to be for varying the setback requirements for buildings and earthworks, so that if you're on the schedule, you get the advantage of a 10-metre setback. But if you're not on the schedule, but you're still a water body, then you only get the advantage of a 5-metre setback. And I mean, for example, if we came to the view that there doesn't seem to be any rationale for that distinction and said the setbacks are the same, then effectively Schedule 9 is really just a list of water bodies that are linked then to potential Esplanade Reserve requirements. So look, I think it's something worth considering, and I guess to some extent it all leads from, you've started this chapter with a policy which actually says you're going to identify, map and schedule, and to some extent that might be the problem, but I don't know. I'd be very interested in you thinking about it, because the MPS-FM and indeed the very coherent and compelling case we had from tangata whenua really does warrant us thinking about these and how we manage land use around water bodies in quite a different way. And if we're going to be top of our game in terms of forward-thinking planning, then I guess the signal from me is that we're going to embrace that, or I'm going to embrace that and run with it. Really. Anyway, that was just my thing. I think it's worth a good think about. Really.
right.
Commissioner McMahon, do you have any other questions, or Commissioner Coffin on this topic?
I do, Stephen. I just want to follow on from Kit's comments there. I'm a stickler for alignment between objectives, policies, and methods. The method, as described in the policy, is to identify and schedule. So if there is a departure from that, we need to see some scope to alter that policy. Of course, identification may be through a definition as opposed to scheduling. So that then raises the question as to which definition you use, water bodies or natural water bodies. And I think you need to go to the objective to get some guidance on that. It's water bodies with natural character and ecology and other values that are protected from inappropriate activities. So that's sending a signal as to which water bodies are affected. It's just that the policy starting point was to list those in a schedule, and the two rules to give effect to those were subdivision rules and setback rules, not water quality rules. So, and the plan is notified there's a clear alignment. If you're going to recommend a departure from that, I think you need to make sure the alignment still stacks up, and that it's not going beyond the Section 31 jurisdiction of the District Council. That was all. There's not a question there. That's just stating the obvious, obviously. Thank you, sir.
Thank you. Antoine, was there any other thoughts from you?
I think Kit and David have summed it up really well, and certainly from my perspective and the tenor of a lot of my questions, seeing how we're dealing with a district plan and it's within the suite of the different documents and the functions of the council, and all of us giving effect to Te Mana Te Wai in various parts and how it fits and doesn't fit at the present time. We talked yesterday about the journey of giving effect to Te Mana Te Wai and its various parts. So just interesting, just it'd be good to hear from you in terms of what part of the journey we're on at the present point in time.
Yeah, I suppose I just want to clarify that the schedule does still have some value, and then I think it provides.
Yes, yes, I'm not discounting that at all. No.
Oh, I was just going to say that that it does provide some certainty for developers and landowners, and it is a real challenge. Having to look at submissions now with another sort of legal framework. So. Te Mana o Te Wai wasn't just a minor change, it's a game changer. So, and
Simply a shift in thinking, yes.
Yeah, so I think that the iwi submissions, they were really helpful for me. I just wanted to really thank them. And the only other remaining issue for the water bodies was raised by the other sort of network utility operators. So Trustpower talked about their operations. So they have some hydro electricity power schemes which are near water bodies. Initially, I rejected and they wanted an exemption to the rules WBR1, which is the building, to WR3, which is the building, and WBR4, which is the earthworks rule. And initially in my section 42A, I rejected that because the scale that they stated in their submission, I thought may impede public access. But I thought it was really helpful in the hearing that Ms. Kennard actually came with maps, and I could see that the buildings wouldn't impede public access. So I am of the mind to grant that exemption. It makes a lot of sense to me. They're existing activities. So I would look at redrafting that. They also raised another issue around that we have mapped the artificial tail races and they're showing as water bodies. So I will go and talk to the council GIS staff about how hard it is to remove those. It doesn't seem may create problems for them. I could see that. Ms. Kennard also recommended an amendment to WBP2, and I think an amendment to a policy. They wanted an exclusion from that policy, and I'll just need a little bit more time to think about that, because I don't want to create a sort of landslide of things, and maybe they are already, because there's an exemption in the rule, I just need to check whether there may already be another exemption in another policy. So I just want to check. I haven't had time to look at that. Are there any questions on that?
Not from me, other than observation. These hydro schemes create every little complication you could think of across all planning jurisdictions. They all have, because a lot of them are so historical and they've relied on easements and rights and been there a long time. Just being careful about them and new plans is, and they're not going anywhere there anytime soon anyway. So yeah, I think it's wise to take a bit of time and just think those things through. Any other questions, commissioners, on that matter?
The next submission was from Lampro, and it really just related to the that they wanted an exemption from cycle and walking tracks, and it was in relation to the earthworks rule, and that only actually applies in the rural areas. So my reading of the plan is that that the walkways, establishment of a walkway in a cycle and a walkway track in our urban zones would be permitted. I don't know, and I would caution whether we should be having cycle and walkway tracks in an urban area, in a rural area, which may result in quite a lot of removal of riparian vegetation. So I will need to consider that, but at this stage, I don't think that's a good exemption from a rule. I think there should be some consideration. And I mean, I'm not an open space planner in any way or form, and I will probably get some advice from Ms. Davies around the council's approach to that. And my last matter, does anyone have any questions? Sorry. The last matter was just grey-mouthed petroleum. Because I'd removed the recommendation of the exemption under, again, it's the earthworks rule, that earthworks was, you're exempt from that rule if it was permitted by a rule in a regional plan or a resource consent issued by TRC. And Greymouth had submitted that that exemption be retained, and I recommended that it be removed. So I really haven't had much time, but I think I need to go back and look at the rules in the regional council freshwater plan, which may have permitted activity status, and to see whether in fact that underground oil and gas activity pipeline would still have permitted activity status, given the change in the regulations. I did notice that a lot of those, like Rule 61 in the freshwater plan, does have an advice note in relation to the new regs that have come in. So I just want to check that before I can really see whether they would still have an exemption. Like, are they actually, and just I'm talk to the regional council as well about the consenting of those issues. So I think the issue is they don't want to go through, be a permitted activity under the freshwater plan and then having to get a consent for us. So I just want to check the alignment of the consenting. So that's my last. I'm finished. Thank you.
Commissioners, any thoughts on that last point in terms of questions? No. Thank you, Denise. From the panel, just your very careful and considered approach to these matters is just exactly what we need on these tricky sort of subjects. Thank you very much for your help and the way you participated. Greatly appreciated. Thank you. All right, we're moving on to Ms. Macbeth. So you want to take us through where you're up to?
She wished to start today by being very brave to reflect the journey that the council and planners are on in relation to the cultural relationship. So I've never done this before, but I'm going to start with my kipiha. So ko taranaki tamonga, ko makatawa te awa, ko kohanga moa te turanga waiwai, ko Rā Macbeth taku ingoa. So you know me, I'm Rā Macbeth, and I'm the author of the Section 42A report for the Eco chapter. I've listened and considered all evidence presented at the hearing on this chapter. So today I can report back on the questions Commissioner Littlejohn asked me to take back to the team about where within the plan structure the subdivision provisions sit and the general compliance with the national planning standards of the subdivision provisions. I have some comments about notification statements in relation to RMA sections 95E, affected persons. I think throughout the session here, we might have some things pop out in relation to the planner conferencing, and wish to respond to a number of matters raised during the course of the hearing and offer my view on these matters in light of the submissions presented and questioning by commissioners. So there'll be some matters I can provide clarification on and hope to close off today, and other matters will require more time to formulate a response and would be included in my written right of reply and following the expert conferencing. So for the most part, I understand the concerns raised by the commissioners and accept the eco provisions are not quite in the state to deliver what they are intended to deliver, particularly in respect of the consent pathway and for all manner of activities, not just regionally significant infrastructure. So I'll be entering conferencing with an open mind and may amend my recommendations. Therefore, in terms of the recommended amendments to provisions, I'll provide the next iteration of Appendix 1 with my written right of reply. So Dr. Shaw and Mr. Shaw and Dr. Herbert are online, and the three of us will just welcome any questions along the way.
So welcome, Willie and Sarah. Do you want to just turn your videos on, just so you're part of the, okay, there you go. Thank you. And welcome back to both of you. And Sarah, thanks for hanging in and hope you're feeling okay. Thank you.
Okay, I'll start with the subdivision provisions and the national planning standards. So the planning standards state, if the following matters are addressed, they must sit in X chapter for most topics. For example, management and maintenance of biological diversity must be located in the ecosystems and Indigenous biodiversity chapter, and provisions to protect and manage historic heritage must be located in the historic heritage chapter. Where the plan's provisions do not fall neatly into one of the chapters, i.e. they are addressing more than one matter, for example, earthworks near notable trees, we have sought advice from MFE and adopted their guidance by asking the following questions. Firstly, what is the overall purpose of the provision? Does the purpose of the provision relate to protecting a value or managing a risk where the appropriate heading is already provided in the structure, even though the provision may also relate to something else? For example, signage on heritage buildings. Is the purpose of the provision mainly to preserve heritage values? If yes, then historic heritage will be the best location. But if this provision is more about wider effects or an overall strategic approach, it would be placed in the signs chapter, and the instruction to include a cross-reference between the chapters so that the provisions can be found from either location. And the other question is, what are the effects being managed? Does the provision relate to specific places of value? For example, an avoid policy relating to earthworks and outstanding natural landscapes would most likely belong in the natural features and landscapes chapter. Alternatively, if the policy was more concerned with managing the general adverse effects of earthworks, wherever they occurred, the earthworks chapter would be appropriate, again, using cross-referencing to the subsidiary chapter. So it's about what's the home chapter. Where subdivision rules have been located in a chapter other than the subdivision chapter, this will be because the overall purpose of the provision was more strongly related to protecting a value or managing an issue or risk pertaining to the matters addressed in the relevant chapter, i.e. the provision was primarily required to manage an effect on a particular feature rather than being for simply managing the general effects associated with subdivision as an activity in and of itself. This also applies for Eco R6, which is different to the other subdivision rules and overlay chapters in that it provides subdivision entitlement. Notwithstanding the difference, the overall purpose of Eco R6 is to protect and maintain Indigenous biodiversity. To locate it in the sub-chapter would not provide as clear a link or line of sight to the outcome sought for that provision. So the team therefore can report that the location of the subdivision provisions were given careful consideration, noting also that we're a pilot council and that we spoke with MFE extensively during the formation of the plan about the structure of the PDP. We consider we've applied a consistent approach with logical reasoning, and our preference is to retain the subdivision provisions where they are currently located rather than moving them all into the subdivision chapter. And we consider this enables plan users to more quickly understand the issue and effects those rules are seeking to manage. That's all I have on that. So
I think we'll start with Kit here. That's if you want to ask any questions, Kit.
No, I mean it makes sense. I certainly acknowledge that of the majority of the overlay rules, they are all focused on protecting the feature. It is R6 in the eco chapter, which actually creates another subdivision opportunity, but look, to some extent, it's if council is happy that they've followed the national planning standard, then I'm not going to interject and say I disagree with them. So then it really just becomes a question of whether the substance of the rules looked at across the plan all sort of works together, and that's more of an integration approach. And I suspect we could deal with that potentially in the context of the subdivision chapter, because the other rules are all very much, if you do X and there is this feature, then you shall do Y sort of stuff. So no, look, I've got nothing further. I think that's a pretty robust explanation.
Sorry, I'll just add that Eco R6 and Sub R4, which it relates to, they're quite connected, and we're trying, Ms. Lawrenson and I have tried to ensure that they are the way that they integrate.
All right, that's good.
So, and that will be something that you'll probably want to explore with us either now or in the subdivision chapter. So note that the amendments that Ms. Lawrenson's made to the subdivision chapter do strengthen that link to Indigenous biodiversity.
David or Antoine, do you have any follow-up questions?
Nothing for me, thank you.
And nothing from me, Stephen.
Thank you, Ra. Carry on.
So before I respond to Commissioner McMahon's query around notification statements, I just have a few things to say about the tangata whenua submissions. That I feel very privileged to have heard the tangata whenua submissions this week. Most council planners are quite new to the concept of mataranga Māori and what it means. I also always love listening to the kōrero and learning from tangata whenua, and I really appreciate those submissions. Thank you. Sometimes it's difficult to reconcile the Te Ao Māori worldview with modern land use in New Zealand. I'm hopeful that the RMA reforms and the MPSIB will, bridge that gap to some extent. Ms. Marco's evidence yesterday showed some poor examples of land use practice in proximity to water bodies. They're the exact reason why we have taken the approach we have in the PDP and have built the framework for change. However, the plan can't be all things to everyone or change attitudes overnight, but change is occurring. As outlined in hearing 1, paving the way for tangata whenua to have a meaningful role in decision-making was one of our top 4 strategic priorities. Ngā kaitiaki played a crucial role in facilitating both relationships and understanding between council and iwi and hapu in the district planning context. We have heard through ngā kaitiaki that only tangata whenua can identify impacts on their relationship with their culture, traditions, ancestral lands, water bodies, sites, areas and landscapes and other taonga of significance to Māori. And you can see this position reflected throughout the PDP, including at the highest level in the strategic objectives. The objectives, policies and matters of discretion reflect a strong role for cultural expertise. Other tools such as structure planning and design guidance feed into this approach. What we are trying to do is increase participation. It comes down to implementation, which is improving every day. The relationship between council and tangata whenua is an evolving one, and I believe it's heading in the right direction. It can be challenging dealing with the public and shifting behaviour, but as a council, we are committed to this change and ensuring our PDP is implemented the way it was intended. So on to the notification statement, section 95 to 95G of the RMA, which set out the requirements for notification of resource consent applications. Council must follow the steps set out in these sections and to determine whether to publicly or limited notify an application for resource consent. Part of this notification decision is determining affected parties under section 95E. And section 95E requires council to have regard to statutory acknowledgements. As part of the kōrero around tangata whenua engagement, and in particular in relation to the Waterbodies chapter and Te Mana o Te Wai, Commissioner McMahon asked whether notification statements should be in the plan to set realistic expectations of applicants and the community around engagement with tangata whenua. So assessments for the purposes of resource consent notification are undertaken on a case-by-case basis and are dependent on many site and application specific variables. Given this, in general, our approach has been that it's generally not appropriate for the district plan to specify when notification must occur. In my view, Commissioner McMahon's question has merit, and given what I've just said about the intention of a strong role for cultural expertise, and the NPDC are trying to increase opportunities for tangata whenua participation and decision making. Officers are currently of the view that the objectives, policies and matters of discretion carry out this function, but we would just seek some additional time to further consider the use of notification statements. In hearing two, I understand Mrs. Edwards advised the panel that the PDP only contains limited instances of notification statements. Understand that's the NU chapter, and then some indirect notification could arise from some standards in the energy, earthworks and noise chapters. So the team requests that we reserve recommendation until the written right of reply here. While we acknowledge the points made by tangata whenua and Commissioner McMahon, we have used them sparingly across the PDP, and any change in the approach requires a cross-plan consideration and legal advice. So we just would like a little bit of time to work through that with Ms. Wallace.
Thank you. Any questions on that suggestion or that summary and that suggestion from the panel?
Excuse me, Chair, maybe I can kick off. That sounds really sensible to me, Ms. Macbeth. I certainly just want to say I'm not pushing a barrow here. I'm just trying to ascertain again the linkage between the objective of participation and the policy and rules as to how that objective is implemented. And if the answer is that the objectives, policies and matters of discretion are sufficient to provide guidance at the section 95 stage, then, and that's your view, then I'm happy with that. If it needs to go further and specify situations where limited notification or specific parties might be notified, then that needs to be justified in terms of scope. And I guess that's my only codicil is I asked those questions without the benefit of whether there was any scope to do that. So in your consideration of this in your written right of reply, that might be your starting point.
Thank you.
Thank you, sir.
Thank you. Any other questions, Commissioner Coffin?
No comments from me.
Thank you. And I have no questions either, so we'll roll along. Thanks.
So I will now move on to my comments on matters explored through those verbal submissions. So I just intend to give a bit of airtime to the rules-based approach, the obligations under section 6C, section 31, in respect of Indigenous biodiversity. So we've heard a lot of evidence on both sides about that. Key issue 2 in the section 42A report considered the general approach for rules of Indigenous vegetation disturbance in SNAs in the coastal environment. We've heard from some submitters who remain outright opposed to the rules-based approach in the district plan to SNAs, and such submitters are typically private landowners as well as conservationists. They consider council should solely rely on the carrot and the stick is not needed. We heard from people who have been actively protecting and enhancing Indigenous vegetation on their land for decades, since well before SNAs were a thing in the district plan. It's my view that the threat of widespread clearance of Indigenous biodiversity is not what it used to be. On the contrary, landowners actively plant, fence off and restore areas. The Environment Court in the 2015 decision relevant to this district at paragraph 67 notes that from consideration of the RMA provisions relating to the sustainable management of SNAs, there may be methods of achieving the purpose of the Act other than the insertion of policies and rules in the district plan. However, at paragraph 87, I quote, "We have substantial reservations as to whether or not leaving the protection of SNAs up to the attitude of landowners in the district provides for the level of protection of significant Indigenous vegetation and habitats required by 6C. So my planning view, having heard all of the evidence, is that the council's rules-based approach, supported by non-regulatory methods, strikes an appropriate balance to meet council's duty to adequately recognise and provide for the protection of areas of significant Indigenous vegetation and significant habitats of fauna in the district, and to maintain biological diversity. So on one hand, we have landowners saying we don't need rules, and on the other hand, we have heard from submitters who consider there should be rules for all Indigenous biodiversity, not just identified SNAs. And they consider that without a general clearance rule, the council is not meeting its duty to maintain Indigenous biological diversity as required under RMA Section 31. In the Section 42A report, I highlighted the difference between the council's RMA Section 6C responsibility relating to the protection of areas of significant vegetation and habitats of fauna, and the Section 31B3 responsibility relating to maintaining biological diversity. I do not take from Section 31 that all Indigenous biodiversity, that every specimen must be protected. Biological diversity is about the diversity of species. Excuse me just stepping through this, but having 10 specimens of the same species is not more biologically diverse than 5 specimens of the same species. Having 5 specimens of different species is more biologically diverse than 10 specimens of the same species. And so to achieve the maintenance of biological diversity, it is my view that the focus can be placed on SNAs, these being areas known to include attributes of rarity, containing species with threatened or at-risk status, representative examples of the ecological district's vegetation and fauna, and reduced ecosystem types. Loss of these significant areas would mean the loss of biological diversity. And in the Environment Court decision at paragraph 25, it states, and I quote, "For the sake of completeness, we record our understanding that reference to the maintenance of Indigenous biological diversity in Section 31, 1B3 relates to the significant areas and habitats referred to in Section 6C. And this makes sense to me because the loss of areas of Indigenous vegetation and fauna not meeting the significance criteria is a much lesser risk to biological diversity." And this leads to the question of confidence in the SNA identification process. The question of, are there large areas that meet the criteria that have not been mapped? It is my view, based on the advice of wildlands experts, that the vast majority of vegetation that meets the criteria is identified. In day 1 of hearing 5, Commissioner Daish commented that it seemed the significance criteria in Eco P1 sets a low bar. In my view, that bar is low. A conservative approach was taken to the identification of SNAs. And this is confirmed in the Environment Court decision that considered the methodology used in the identification, noted at paragraph 110 of the decision, that one of the matters that surprised the court in hearing the case was the lack of dispute around the desktop exercise undertaken by Wildlands being sufficient to accurately identify SNAs in the district. This was echoed by the only ecological expert to appear at this hearing other than Wildlands consultants, with Mr. Larcock appearing for DOC, confirming he was comfortable with Mr. Shaw's evidence around the significance criteria, the Wildlands methodology for the identification of SNAs, and that the ground truthing has been a significant exercise and an important component. Mr. Larcock was asked by Commissioner Coffin what is missing, and he replied that he is not saying anything is missing, but sometimes you come across something that hasn't been found before. In the absence of expert evidence demonstrating areas that meet the criteria that are not within the SNA overlay or otherwise legally protected, I maintain that the wildlands identification can be relied upon, that it is the best information available, that it has been ground truthed, and there is no evidence to dispute it. Notwithstanding this, it is acknowledged by Wildlands and confirmed by Mr. Phillips when he appeared, Mr. Phillips being the QE2 representative, that there may be areas not identified. I consider it's also possible that there are areas that do not meet the criteria that have been identified and due to some sites haven't been visited. So Dr. Herbert, Mr. Shaw and I are of the view that as Commissioner Daish used the term swings and roundabouts. Commissioner McMahon has been asking questions about, that risk and referring to that land eastward of the coastal environment line. And in particular, we stated at the start of the hearing how the Egmont Ecological District, the ring plain is a key area of risk. And wildlands are particularly confident in the work done on the ring plain, where there's greater fragmentation, smaller pockets and corridors compared to the larger, more contiguous areas in North Taranaki. I've discussed with Mr. Shaw and Dr. Herbert how, ecologically speaking, the more Indigenous vegetation prevented from being cleared, the better. This is obvious. However, I do not consider a rule preventing disturbance of Indigenous areas not meeting the criteria as necessary in order for Council to meet its RMA obligations to protect areas of significant Indigenous biodiversity or to maintain the biological diversity of the district. I found the tangata whenua submissions very enlightening, and the interconnected nature of ecosystem components explained from a Te Ao Māori worldview and the submissions describing cultural values associated with Indigenous biodiversity, they present a compelling case for a general clearance rule. Furthermore, as discussed at the strategic direction hearing for the PDP, it is my view that the PDP seeks to improve the natural environment. However, having heard all of the evidence seeking a general clearance rule and the broadening of the reach of the chapter, I do not consider it efficient or effective to have rules for disturbance of all and any Indigenous vegetation. In the Section 42A report, I recommended rejecting the submission of DOC, which was further submitted on by tangata whenua in support of a general clearance rule and to broaden the scope of SNA definition, which would therefore broaden the reach of the rules. I've given a lot of thought to this when writing my report and listening to evidence. I have kept an open mind. My mind remains open to the possibility as I enter the conferencing, because I personally and professionally would not like to see a loss of the district's biodiversity in those many areas where we don't know what we don't know. But in the form of the rule that we have before us from DOC, I'd just like to talk about that, because in the original submission, DOC sought a rule for vegetation disturbance outside identified SNAs, whereby 250 square metres of disturbance would be permitted, providing it did not meet the significance criteria in Eco P1. And a key reason for my recommended rejection of this was in the 42A report was that it would require ecological assessments for all activities that involve disturbance to assess whether the criteria was met, and I considered this was onerous and inefficient. Then the DOC evidence at the hearing removed that requirement to assess the first 250 square metres for significance, making it slightly more palatable to me. However, for a number of reasons, I still believe that general clearance rule outside SNAs is inappropriate. For a start, 250 square metres is a small area. It's barely a building platform. In 2005, a number of approaches were discussed with stakeholders, and a general clearance rule was considered at that time. And it's my understanding that that stakeholders, DOC, Forest and Bird, agreed that SNAs being identified and subject to rules was the preferred approach. Considerable investment of time and resource has ensued, and to identify the additional 20 hectares of SNA, which are finally now within the PDP and subject to legal protection.
Was that, sorry?
Protection under the district plan chapter, sorry.
Yeah, I think you said 20 hectares.
20,000.
20,000, yes.
To now introduce a general clearance rule would render that work pointless. It would duplicate the SNA process and undermine the considerable cost and effort of identifying SNAs in the first place. We've heard the district's journey over a long period of time. It's taken a long time to reach the point of reluctant acceptance for regulation of SNAs. Some landowners are still not in acceptance. Very concerned about the potential impact on council and landowner relations and goodwill if we were now to introduce a vegetation clearance rule that applies to all landowners. Ms. Walker's submission talking about the reluctant acceptance by many farmer SNA landowners, it's the result of time taken to develop good landowner and council relationships and the council's commitment to ground truthing and the draft workable rules. The importance of the on-the-ground face-to-face meetings and relationship building should not be understated. It would also be a significant change to the PDP as notified with widespread application, and I would have concerns around lack of engagement with the community before implementing such an approach. And I do not consider that the general clearance rule for outside SNAs in the coastal environment is the most efficient and effective way to achieve the purpose of the Act. It'd be extremely difficult to implement and monitor such an approach for both council and landowners. Notwithstanding my view that the general clearance rule outside the SNAs and CE is inappropriate for our district, in the conferencing, I intend to discuss potential parameters for such a rule outside SNAs. In particular, I am keen to hear from Ms. Yosen whether she is aware of rules and other plans which are effective in addressing the scenario where a serendipitous finding of an ecologically special specimen could be protected. I do not consider the rule DOC if proposed would pick up the types of serendipitous find Mr. Lacock talked about. The examples he gave were daisies, herb fields, vegetation that you couldn't easily pick up from aerial photography in a desktop assessment. And fauna has also been identified by some submitters as a crucial aspect that the PDP isn't protecting. But I expect that being allowed to clear 250 square metres as a permitted activity could result in the disturbance of vegetation, habitat and fauna that might be rare or threatened, therefore significant. So in terms of the effectiveness of the rule that's before us, yeah, I don't support that. In my view, the risk of not acting in respect of the general clearance rule for outside SNAs is low. That is, the risk of areas containing significant vegetation and habitats being unidentified and unprotected, and the risk of reduction in Indigenous biological diversity is low because of the confidence in the wildlands assessment, which captures the vast majority of areas that would meet the criteria for SNA. And to see this alongside all the restoration projects and predator control occurring in the district, and further that the culture of the district is predominantly one which values Indigenous biodiversity. Another consideration for the maintenance of biodiversity is that maintenance requires so much more than rules stopping vegetation clearance. Animal and pest plant control are crucial and generally the responsible of TRC under the Regional Pest Management Plan. MPDC makes a contribution to this work, including coordination of MP's New Plymouth trapping network and as owner of a considerable amount of reserve land. And thousands of the district's residents make a contribution to the protection and maintenance of Indigenous biodiversity with their backyard trapping, restoration projects. People are adopting trap lines on the Monga. We've heard from the evidence of the communities mobilised and restoring. Throughout the hearing, the picture has been painted of a district characterised by collaboration and an integrated approach between landowners, tangata whenua and multiple agencies with multiple projects on the go. The council carries out a range of non-regulatory actions. It delivers a palette which I consider meets the council's obligations in accordance with the findings of the Environment Court. So the reach of the eco provisions depends on how much of the district's Indigenous biodiversity lifting the PDP is expected to carry out. I don't believe it is all on the PDP. But I do consider the SNA identification and framework do a very significant amount of the heavy lifting, and certainly enough to ensure that the council meets its obligations under section 6C and section 31(1)(b)(3). So, but to acknowledge that the identification to date has been based on ecological values, and wish now to consider RMA section 6E. So 6E would be recognised and provided for, in my opinion, through the SNA identification significance criteria being expanded to include tangata whenua values and or Mātauranga Māori. I note the panel's questioning of the tangata whenua planning experts. In paragraphs 314 and 315 of my section 42A report, I considered the relief sought from Te Atiawa, Ngāti Mutanga, Ngāti Maru and Taranaki iwi, that the use of Mātauranga Māori be identified as an additional significance criteria, with these submitters noting this would accord with objective Eco 03. In my report, I stated the council is supportive of the incorporation of Mātauranga Māori and the identification of taonga species in the management of the district's biodiversity. However, fully exploring how Mātauranga Māori can be incorporated into the chapter in a meaningful and appropriate way would require a dedicated project that would fall outside the district plan review. My recommendation to reject that request from tangata whenua is to include an additional clause to Eco P1 was based on my reservation from a process perspective, that because the areas haven't been identified yet, that the policy would be falling short. Mr. Wakaira and Commissioner Littlejohn had a discussion around that they hadn't come across any situations where significance criteria strays beyond ecological science. And Ms. Wakaira suggested this is an opportunity for MPDC to take leadership to respond to the expectations of tangata whenua, and noting that section 6C and 6E could be reconciled. So Dr. Herbert has pointed out to me, so I'm aware of one council that has beaten us to it. Policy 23 of the Wellington RPS relates to criteria to identify significant areas. They have 5 criteria, 4 being the ecological matters, similar to the PDP criteria for representativeness, rarity, diversity, and ecological context, and the 5th criteria being tangata whenua values. The ecosystem or habitat contains characteristics of special, spiritual, historical, or cultural significance to tangata whenua identified in accordance with tikanga Māori. And that criteria is a bit more broad than the than clause 5 put forward by the tangata whenua planning experts. I've forwarded that to Ms. Mako, and that would be a matter that I think we need to talk through in the conferencing before I make a final recommendation on that. So such a new criteria in Eco P1 would cascade from Eco 03 and to the permitted standards of Eco R1 and Eco R2, which provide for gathering plants in accordance with Māori customs and values, and to the subdivision rules, matters of control. And I consider it's also supported by Eco P5.5 and Eco P7.5. I consider any changes to the SNA mapping, however, wouldn't including additional areas requested by tangata whenua under a Mātauranga Māori criteria would require a plan change. However, the council is anticipating working with tangata whenua in such an exercise. And I note the strong signal in the draft MPSIB, including additional Mātauranga Māori criteria in Eco P1 would open the door to that project of identifying culturally significant biodiversity. If gazetted in its most recent form, the draft MPSIB would require local authorities, when making or changing policy statements and plans involving tangata whenua in accordance with tikanga Māori and collaborating to identify taonga, recognising tangata whenua have the right to choose not to identify taonga. So I guess we have that in mind, that that's around the corner with the MPS. I also appreciated the questioning by Commissioner McMahon of Ms. Hokapolder, whereby he asked whether Eco P15 was solely for plan making. Maria responded it would be ongoing for subdivision. There was the comment that it would have some legs in the implementation, and I concur with that. It could be used in the subdivision space, particularly when I look at the amendments that Ms. Lawrenson is recommending in the subdivision chapter in respect of Indigenous biodiversity. In summary, having heard all the evidence, I wish to recommend that I will be recommending an amendment to Eco P1 to include a criteria relating to cultural biodiversity values. Just to move on now to the matter of the protected land.
Could maybe a pause here, because I have a couple of questions and comments, and Commissioner Coffin sounds like he might have a question too.
Yeah. Maybe happy for me to ask that question.
Yeah, go ahead.
It's just to make sure that I heard right, because I thought there was two things. One, you weren't predisposed to, my words, tinkering with Eco P1 in regards to Mātauranga Māori because of the implications of what might occur as a result of that. But then I'm hearing you saying that you are looking at including a criteria in Eco P1, and there would likely be, as a result, a new project that would need to be developed sitting outside of the proposed district plan that's preceding that. Can you just clarify what you said?
So, sorry, I wasn't clear there. So I was just recognising that in my Section 42A report, I rejected those submissions.
Yes, okay.
And now I am intending to accept them. To include a criteria.
Story of the journey. Thank you. That's great. Thank you very much.
Okay, and I do have a couple of questions along the way here. You mentioned early on in your position statement that you've read out on this matter that early on in the process there was a meeting or something between Department of Conservation, Forest and Bird and MPDC, which set the course of travel around mapping SNAs.
Yeah, that's what came out of the consent order.
Yes, okay, so that's the consent order. Yes, and you've relied on that to do all this work.
Yes.
Yes.
And Mr. Shaw also might be able to provide some insight about the options that were talked about way back when. And there were a range of options that Wildlands presented to us and then what was landed on was the SNA path. So Mr. Shaw, would that be helpful?
Yes.
Yeah.
Yes.
Mr. Shaw, would you be able to talk to that, please?
Yes, kia ora koutou. Somewhere in my evidence, I've set out those options, and from memory, it was in 2007. There's 4 or 5 options, including, a rules-based approach, a general clearance rule, and right through to the comprehensive SNA approach, which has been adopted. And I talked about those options at least one SNA liaison group meeting, and my understanding is subsequent to that meeting, and I wasn't party to later discussions, that it was decided that the comprehensive SNA identification approach would be adopted. There was certainly a lot of support for that approach from a number of parties in the discussions that I was involved in before a decision was made, and the support for that approach was based on the concept of certainty for landowners in particular, that they would understand that there was something of significance on their land because it was mapped and clearly identifiable. And in the case of many farmers, they may not may not have liked that, but at least they would know that there was an SNA there and something of value that they needed to plan for and accommodate.
Thank you. I just would, the five options are at paragraph 7.25 of Mr. Shaw's evidence.
Right, thanks for that, Ms. Macbeth. My second question, I suppose, is you've said in it a few times through the statement that you have an open mind, which is exactly the duty you have as a expert planner, but you are looking towards, I think, some conferencing on some of these key matters with the other planners in an expert sense. So I'm thinking in terms of our step 2, and I'll get some feedback from the panel on the hoof while we talk about this, is it seems like there are perhaps an agenda of matters that once the identification and the clarification of the positions in step 1 is done, that you'd like to advance in a planners conferencing forum as the next step.
Yes. Yeah.
And I'm thinking for efficiency, if as part of your reporting back on the end of Tuesday, if you could just give us that agenda of the matters that you'd like to cover, we could then just double check that and add anything we thought might be useful.
Sure.
How does that sound,
Thank you.
commissioners? Okay, thank you for that. And I'll let I thought I'd just cover those before we moved on to another more detailed topic.
Commissioner McMahon.
Oh, Commissioner McMahon, is your hand up?
Oh, but I'm happy to put it up.
Okay, yeah, do you have a question?
I think so. I've been making a lot of notes, Ms. Macbeth, about the issues of risk and that, and thank you for acknowledging those matters. I don't have any questions there. I guess in relation to the inclusion of sub clause 5 into Eco Policy P1, it felt a little bit like a Jacinda moment when we were waiting to find out whether the alert levels were changing or not. And at the very end, I guess I wasn't surprised. Well, you caught me on the hop a little bit when you said that you were prepared now to recommend the inclusion of subclause 5, because previously, as Commissioner Coffin indicated, you'd said that maybe you need to leave that to an MPSIB project, and that the policy might not be implemented in terms of the identification of SNAs. So when your recommendation popped up at the end, it did catch me a little bit on the hop. So what is it? And was it because you thought that the policy might have some legs in a wider resource consent process that swung the balance for you?
No, it was before hearing that having had a discussion with the planning manager, that it's work that we are anticipating doing, and that the change in policy would be opening the door to that.
Okay. Policy would be clear. The implementation of it might be for another day, though. Is that what you're saying? In terms of identification?
In terms of identifying and mapping in the E-plan.
Yes.
In terms of subdivision on a case-by-case basis, I think that could be a relevant policy to support tangata whenua's involvement in the management of Indigenous biodiversity.
Okay, no, that's good. Thank you for that clarification. Presumably you're going to get on to another topic in relation to no, I'll leave that. I'll come back to that later on. No, that was all. Thanks.
Carry on. Thanks, Ra.
Yeah, I think just to follow up on that, I think what what did change things a bit for me was the comment that there's nothing in section 6C that limits the significance to ecological matters. That I think that was in Maria's evidence. Thought that was a very good point. So on to otherwise legally protected land. So we've heard from some submitters seeking that when SNAs become legally protected by way of a covenant or other mechanism that they should not be removed from the plan. The reasons for this include that sometimes covenants are not specifically for biodiversity reasons and that council should not divulge its responsibilities to other parties. In my view, the number of covenants currently in place protecting values other than biodiversity values would be minimal. I do acknowledge this concern. I meant to check with my colleagues that were involved in the process before me. I understand there was some kind of exercise to look at the details of covenants. Can you enlighten us? Was it Ms. Dravitsky did some work on that? It might be something I could look into before my written right of reply. But in my view, the number of covenants in place would be low. And I consider that the recommended new definition for conservation covenant, which was put forward by QE2 and which I've recommended adopting, would address this concern going forward, as it states that the covenant must be to protect an area for Indigenous biodiversity. Regarding the concern that council divulges its responsibilities to other agencies, for example, QE2, I note that there are enforcement mechanisms available under these covenants, and Mr. Phillips has advised me that prosecutions do take place under QE2s. Given that protection, including its enforcement abilities, exist under the covenant framework, not duplicating this protection is a matter of efficiency and effectiveness, with a low risk of not acting. On this basis, I maintain my view that the district plan does not need to provide a further layer of protection. It's just been very interesting listening to some landowners, sort of on the matter of psychology of conservation, maybe. And some of those submitters just demonstrated that delicate balancing act of bringing landowners along on the SNA journey. And I just in particular remind you of the submission of Mr. Coleman, who he was interested in a QE2, but then felt concerned that with forest and bird seeking that it remain in the district plan, then he got put off that idea. I would like to acknowledge the shortcoming raised by Maria, that QE2 covenants do not provide specifically for involvement or expertise of tangata whenua. I've looked at a few conservation documents, covenant documents, and I do note that they typically provide for landowners to allow people into the area. So I don't think they're a barrier for if tangata whenua wish to have a relationship with a private landowner, then I think that could, that wouldn't be that would be available, and this may be a matter that the council could, we have this relationship with QE2, so maybe that's something that we can move towards recognising. But yes, I do acknowledge that note that Maria made. So later I'll talk about particular sites that whether they're in or out based on their protection. So, but now I'll just have some comments around whether the provisions are appropriate in respect of higher order documents, such as the NZCPS, the RPS, MPSET. First, I'd just like to clarify that the MBA and draft MPSIB, in my view, are not in the tent in respect of the legislative framework. They indicate the direction of travel we can expect through the RMA reform, but there's a lot of uncertainty and it would be inappropriate to consider that we must give effect to anything in those. in submissions in respect of the NZCPS, some submitters felt that well, they sought to ensure that Eco P4 and Eco R2 give effect to the requirements of Policy 11 of the NZCPS. So Policy 11 is all about Indigenous biodiversity in the coastal environment and has a three-stepped approach of firstly, avoiding adverse effects on Indigenous vegetation or taxa that is nationally significant, threatened, or is naturally rare as described in Policy 11A, excuse me. And then avoiding significant adverse effects, and then avoiding, remedying, and mitigating other adverse effects on areas, habitats, ecosystems, etc., as described in Policy 11B. So I wish to explore P4 further in the planner conferencing and appreciate the wording put forward by Ms. Hepworthwaite and Ms. Yosin. And I can flag that yeah, I may shift my view on P4 about whether we need an extra step in there. And I was particularly concerned that Commissioner Littlejohn was losing sleep over that one. So I'll try and improve that a bit. So while I'm on the coastal, on day one of the hearing, I'd just like to talk about the mapping. So the mapping of the CE, as I stated on day one, involves a range of values and hazards to reflect the requirements of Policy 1 of the NZCPS, which outlines the extent and characteristics of the coastal environment. Mr. McMahon asked me to clarify the extent of the CE and potentially to show it on a map. So it's a bit difficult to show the detail. I think you're after over a 100-kilometre coastline. I had in mind that I would prepare a GIS demonstration at the hearing of the coastal environment topic, and I haven't had the chance to prepare that now.
That is mapped in the E-plan.
Yeah, so you could scroll up the coast and see how narrow, and you can measure it. And I have done a little bit of an exercise, which I'll try and verbally explain it now, and perhaps in my written right of reply, I might just include a few shots that visually show that. So
and I know in Kapiti, because I was involved earlier on that, there was one you could actually, there was a line drawn on the whole district.
Our coastal environment is with the blue patch.
The blue patch. Yeah. Okay,
thank
you.
And in it, we haven't sort of specified within it why that particular area is in the coastal environment. And that's just a matter of simplicity of plans, and that it would just be really too cluttered and difficult. So, so we've just got this broad coastal environment, which I believe reflects the requirements of Policy 1 of the NZCPS, but probably to be scrutinised at a later hearing. But in respect of the vegetation, hopefully I can set your mind at ease through what I'm about to say. So the starting point for that mapping was the most inward line from the coastal hazard data that Tonkin and Taylor have prepared for us for the coastal hazard management. And at the narrowest, it's around 70 metres wide. And then in other places, it's up to 1 kilometre wide. Just in a few places it goes that wide, and I'll come across some of those in a minute. They are typically for ecological reasons. So we started with the RCP 8.5 plus climate change scenario. And apologies if people aren't familiar, but that's the worst case scenario over a 100-year time frame that Tonkin and Taylor developed for us. And then where we considered the values, and we also had the coastal flooding overlay, which is at 8.5, RCP 8.5. We can get into the detail of that at the later hearing, but and then the values on top would drag that CE line further landward. So we started with the hazard data. Where SASMs straddled the line, the CE mapping would come in to cover those sites to reflect that cultural coastal landscape, and that was an exercise carried out with our GIS person, myself, and iwi relationships person who's has intimate knowledge of these sites. And we also had a coastal character review, which Mr. Bain completed, and he can give evidence on that on the coastal environment hearing. And then we have Appendix 20 in the Operative District Plan, which is significant coastal areas. And this includes estuaries, mapped extensive river mouths, and there is some detail of vegetation values in there. And so we basically rolled these areas into the CE as well. And then biodiversity values were considered. So as part of the coastal SNA, which I mentioned was covered approximately 195 properties, and they haven't been ground truthed. But the SNA was considered, and in 3 places that dragged the line further inland. So yeah, as I said, at a minimum, the CE is about 70 metres wide, and in some places it's considerably wider. And 2 areas that I would point out where it drags in approximately 1 kilometre is Lloyd's Ponds. So this is and at the Omata tank farm near Paratutu, and then the Waipu Lagoons, which is in council-owned Hickford Park at Bell Block. So they're coastal lakes with high biodiversity values based on information that I was aware of from TRC. So I made the call to include them in the CE. And yeah, I would provide some images in the written right of reply to demonstrate that if that's helpful. But yeah, and I would also just encourage you to scan the coastline. And
Thank you. Any questions on that topic, commissioners? No, we're all happy, thank you.
I just wish to make some comments on the RPS. So at the start of the hearing, I indicated my view that the RPS is generally fit for purpose in respect of Indigenous vegetation. And since then I have carried out a closer scrutiny of the bio chapter. And I just make the following comments. The bio chapter and other parts of the RPS, but so, you know, the RPS may be deficient in respect of Mātauranga Māori. It is issue 16, as Ms. Bellamy outlined yesterday, talks about the Treaty of Waitangi, recognises kaitiakitanga, ancestral relationships in Tonga, but the term Mātauranga Māori isn't present in the RPS. I also consider it may be deficient in the offsetting and compensation, which is included in the 2017 RMA amendments, is not mentioned in relation to effects management of Indigenous biodiversity. But there are tools that we wish to include in our plan. And the RPS has some catching up to do in respect of water bodies in the coast. The RPS doesn't give effect to the NZCPS 2010. However, the proposed coastal plan for Taranaki, the decisions version October 2019 is recent and fit for purpose. I note that it includes Schedule 4, significant Indigenous biodiversity, and Schedule 5, which lists coastal Tonga species. So I'm not familiar with how the items listed in those schedules were derived, but there is some information in there. And in respect of alignment of our coastal environment with the proposed coastal plan for Taranaki, it references the line and district plans.
Okay.
So that was a matter that that's how that evolved through some integrated management and our submissions on that plan. I understand it was from a submission on the plan.
Can I just ask you a question about the regional coastal plan and the district plan? What's your opinion in terms of level of plan? The coastal plan is not a high level document in your view, or is it?
I think it is, but yeah, I think so.
My understanding is you have to give effect to it in the district plan.
Okay.
There's a hierarchy.
Hierarchy there.
Yeah.
And what about the question I had on iwi management plans yesterday?
Now, I understand that we wouldn't call it a higher order plan, and I will, if it pleases you, provide more comment in the written right of reply.
Mm.
So under section 74 2A, it says a territorial authority when preparing or changing a district plan must take into account any relevant planning documents recognised by an iwi authority and lodged with the TA to the extent it has a bearing on resource management.
So it's all those words, those have regard to, give effect to, take into account, not inconsistent with.
Yeah, it's have regard.
Yes,
Sorry,
Sorry, can I just
yes,
make
yes, sure.
take
Yes.
into account.
Yeah, we have to give effect to the RPS.
Yes, that's right.
And the regional plan, I think, is it not, what's the word? Is it have regard to?
Yes, I've always
Into
seen the
account.
regional plans and the district plans on the same level of the hierarchy.
I think
Yeah.
the change of the RPS we have to give effect to.
Yes, definitely have to give effect to the, and the
Um,
commit, yes.
um,
I've really asked you about that just to get to that area management plan question, just to get your view on that, because that was, we had evidence that it was thought of as a higher level planning document by Ms. Bellamy. Yes.
So I have had a discussion with Ms. Wallace about it, and we were intending to provide something in the written right of reply about that, in particular, either the written right of reply or Ms. Wallace's evidence around king salmon and in terms of the higher order, how they, there's the hierarchy. Firstly, documents that the responsibility of the central government. Second, documents responsibility of regional councils, regional policy statements and regional plans. And then thirdly, TA, specifically district plans. So that would be my understanding of higher order documents and the increased specificity as you through them.
Well,
So
I've
the
interrupted
criteria
you.
for iwi management plans to be taken into account when making plans is that they must be recognised by an iwi authority relevant to resource management issues and lodged with the council.
Yeah.
So we have detailed them in our section 42A reports of where we think they're relevant.
Yes, and I'll have hard copies of those, so I'm quite interested in those. Sorry, I interrupted you
So
there.
that's fine.
Yes.
So overall, I consider the bio policies of the RPS remain relevant as matters for the eco chapter to give effect to. They're just that there may be some additional matters that we, in terms of Mātauranga Māori and offsetting and compensation, that we go a bit further than what the RPS tells us to. And then my section 42A also considers some relevant infrastructure objectives and policies, and I consider that the chapter combined with the NU and infrastructure chapters of the PDP give effect to these relevant bio and infrastructure RPS provisions. Of course, I'm not sure which one of you asked me, but the relevance of the MPSUD and to the eco chapter. So from my reading of it, it is relevant to the extent of Objective 8 relating to climate change. This was subject of the SD, NE and UFD chapter hearings. We've reported on it through a number of hearings, and it's sort of just cruising along in there. The climate change seems to be just accepted part of planning now, but just related to that, Commissioner Dace, you indicated interested in carbon farming. So I recognise climate change mitigation in my section 42A report in section 4.1, where I just note the role that forests play in carbon sequestration. I have no expertise in the matter of carbon farming, but I do note that there were submissions on the eco chapter in relation to carbon credits, probably associated with, the economic use of land. And my main response to this is in paragraph 340 onwards in my report, where just that the council's method to recognise economic impacts on SNAs on landowners is through the subdivision incentive and rating relief. And I consider these to be meaningful responses to the economic limitations. I just think the carbon farming, I don't feel that we have an obligation at this time, but would be something that I'd be expecting to see in future.
I suppose I've been following quite closely the economists and the financial sector advising, or I suppose the commentary around farming operations, and the fact that in hard hill country, so land units 6 to 8, the profitability of either planting forests, indigenous or exotic forests, and just maintaining those for their carbon value is sometimes 2 or 3 times the returns than you get from farming sheep and beef in those areas. And I suppose my interest is that that's going to lead, that's the case, and I've been following it quite closely, that sort of is another method outside of the plan that will see encouragement of biodiversity. The other topic, and Mr. Shaw, I'm sure, has a lot of knowledge about this as well. That topic also touches on the fact that the Indigenous forest sinks have much more they have more value longer term than pine plantations, but my understanding is they take a lot longer to grow, so there's not such an incentive to get your carbon dollars back quickly if you're either locking away a regenerating area. It's sort of perhaps a quick buck's going to be very marginal land and long-term pine forests. So, Mr. Shaw, you had any? I think we did touch on this in the earlier parts of the hearing.
Yeah, we did, and you're exactly right. When people are planting exotic forests for carbon farms, because of those fast initial growth rates, radiata, for example, I think attains similar sequestered carbon values to Indigenous forest within, I don't know, so 30 to 50 year time frame, whereas Indigenous plantings are probably going to take 80 to 100 plus years to get to a similar state. So there's a very fast return from planting radiata. What that doesn't recognise is that, and there's been a lot of promotion of the planting of radiata for carbon farming on the basis that there'll be a conversion at some point in the future to Indigenous through that radiata canopy. But there are some very big buts here. Although Indigenous understory establishes quite quickly, actually under radiata, radiata is likely to persist on these sites for, in my view, centuries. Because as these stands develop, they will partially collapse, they will self-thin, there'll be wind throw, but there'll also be radiata regeneration. And I've been involved in some conversion, I am actively involved in some conversion projects where people are trying to get what were former radiata plantations back to native, and the sheer scale of natural radiata regeneration on those sites is astounding. Thousands and thousands of stems per hectare, which then has to be subject to active control. So quite a costly process. So this is quite a complex area that's developing really quickly around us right now because of the high cost of carbon in the world market.
But there are some species, I know Totara is one that does grow. It's slow, but it's one of these big big trees that is very effective as a sequester. So I'm just following it quite closely just from my own personal interest in biodiversity, regeneration and those sorts of things. It's probably a bit off topic, but it's something that I think if you're thinking future land use, it's happening now as we speak.
It is relevant to the big picture and the longer game, I think. And Dr. Herbert and I heard from a few SNA landowners when we were doing site visits how they were frustrated that the carbon credits system wasn't working for the people that had not cleared in the first place. I don't really have a response for that in the district plan, but you know, potentially it's something that the council can be in a conversation with central government about. And I think we are starting to get our heads around it in our parks, planting our plants project. So, you know, but it's, at the moment, can't really advise you on that aspect. But
okay.
But anyway, I just got distracted from, so that was in relation to the climate change objective in the MPSUD. And the question of the MPSFM 2020 for biodiversity. So that's focused on inland wetlands. Ms. Young's probably, she's our freshwater MPS guru. But I guess I can advise that the wildlands desktop assessment and subsequently the PDP does identify a number of wetlands as SNAs and have those protection rules on them. And then the MPSET and the MPS REG raised by the Transpower Trustpower. I consider those are well catered for in the NU and the energy chapters and within the strategic direction of the plan, where the panel have indicated that greater recognition in your interim guidance. Okay. So this has been my preparedness teeters out a bit.
So how are we doing for, do we just want to carry on and finish this, baby, or do we want to have a break? And
I'm okay if you're okay.
I'm okay if everyone else is okay.
Have we got a sense of timing? I know we just said that's okay. Does that mean okay is another hour and a half, or is it okay? It's about a half hour.
I hope not. I hope not, because a lot of what I'm going to step through now is just going to be that, oh, well, this needs to be worked through in the planner conferencing, but I can indicate some areas that I feel I will be, you know, I'm very open to movement and some discussions around a couple of definitions and how that might interrelate across the plan.
Okay.
And then we've got a few sites that submitters have raised. So,
Commissioners, can I just get an idea of questions for the ecologists?
Well, I've got a few questions of Mr. Shaw, obviously, around my around the Mānuka and Kānuka issue. I had a couple of other ones for Ms. Macbeth as well. Not so much questions as in things I think I'd like her to reflect on and provide us advice on in terms of the replies. So we can either sort of do a catch up at the end about that, or I can sort of throw a few things out there now if you wanted to. I mean, I suspect we've got a few more hours to go. I hate to say it, at least another hour or so.
Yeah, look, I'm thinking it's 20 to 2. My body's telling me I just need a bit of fuel. So if we come back, my glasses on to read the clock, 2:15. Just have some lunch and a break and a refresh. That would be good.
thank you.
We'll adjourn until 2:15. Thank you.
All right. Thanks, Stephen.
Yes. Good afternoon again. It certainly was a good break to have a bite and underway again. So just back in your hands, Ms. Macbeth.
Thank you. So, yeah, as I said, I've done a table which just to go through provisions.
Stephen, before Ms. Macbeth moves on, could I discuss one of the questions I had?
Yes.
Ms. Macbeth, it concerns this the issue of the schedule, was it Schedule 9, only referring to SNAs that are not otherwise protected. And I know you've addressed us on this, and the position, as I understand it, that you've put forward is rational, and I'm not arguing with it. The concern I have, and it's something I'd particularly like you to consider with Ms. Wallace, is whether what the council is proposing with the proposed district plan does not, despite all of the really good work you've done to identify new SNAs, still fall foul of the same criticisms that the Environment Court declared existed with the operative district plan. And this is, and I do the, you know, I'm loath to sort of bring this up, but if you go to the declarations the Environment Court made, and look at what the operative district plan was proposing, it's quite clear that in its absence of any reference to SNAs that have been formally legally protected in the proposed district plan, there's a potential legal issue as I sort of apprehend it. And that's principally because the Environment Court's declarations referred to the methods of implementation in the ODP of 16.1 and listed all of those as being part of the palette of measures that achieved that overall obligation to recognise and provide for the protection of SNAs. Now, method of implementation 16.1 made explicit reference to Schedule 21.3, which was those SNAs that had already been legally protected, in which they were all listed. And in the context of one of the methods in the plan for achieving that higher order document, the court was satisfied that by listing them there and being satisfied that they were protected, that was a relevant component of the protection measures. And the court was critical of those areas that had been identified by the criteria in 21.1 not being included in the appendix, and that contravened its duties. So I guess where I'm coming to, and it's the point I'd like you to consider, is whether there needs to be some form of reference in the introductory provisions to the eco chapter of all of those areas that still meet the criteria for SNA, but are otherwise legally protected, so that we don't end up in a situation where, for example, another party criticises the council's approach here because it's the district plan itself that doesn't recognise and provide for these other areas. So I guess that's the issue I've identified, and I'd like you to have a think about it. It doesn't seem to me that it needs to fundamentally change the substance of what the council's proposing, but it may require consideration of a schedule that does include all of those protected areas being included in the district plan and at least referred to as part of the overall suite of provisions to deliver on that higher order Section 6C obligation.
Thank you. Yeah, that is a difference between the ODP and the PDP, in that we haven't got that list of the legally protected, and it would be a relatively simple exercise to just create a list. And I think I also see this value in just recognition for those landowners that they have legally protected it. But I haven't sort of tested that with landowners, whether they would like that. That would probably be my only reservation in doing it.
There's an interesting method in the operative district plan which says that following full legal protection of an SNA, the council will transfer reference to the SNA from Schedule 21.2, which are the unprotected SNAs, to 21.3, which are the protected SNAs, by updating the plan without further formality, which is an interesting rule, which I'm not sure whether it complies with the first schedule, but anyway, we don't have to worry about that because we're not worried about the ODP. But certainly there was a recognition there of a process from identification of unprotected to when they became protected, they sort of shifted in location in the district plan. Of course, it's a very different proposition here in that there's not a set of rules that sort of attached to all of those previously unprotected ones. So, but look, I'm just conscious that I'd hate to get to the end of this process and then, for whatever reason, a challenge is made that somehow by omitting to refer to or actually identify these already protected SNAs, that somehow there's a flaw in the plan.
Thank you. Yep. Can respond to that in the written right of reply.
Yeah, thank you. Yep.
Thank you, Kit.
Oh, back to me.
Back to you.
Thank you.
Okay. So you can expect in my next iteration of Appendix 1 that there'll be some amendments to the overview in respect of cross-referencing some other chapters. Just talk about Eco 01, where we have 2 submitters asking for specifying what the Indigenous biodiversity is protected from. And I, having heard the evidence, am not, and I do not intend to change my position on there, but yeah, we'll talk about that at the conferencing. The request from Ms. Calland for trust power on Eco 02 about adding a note about the offsetting and no net loss and net gain. To 02, I have not been moved from my position on that one. I know Eco 03 is one of our two provisions with no outstanding matters as I see it. So that's exciting to have some of those. I've got 2 new objectives requested. So one was from Mr. Kiss. So he had drafted, continue to provide for land use for primary, for industry, farming, forestry, infrastructure and other purposes while maintaining Indigenous biodiversity, which he got from the draft MPSIB. Again, that's something to explore in the conferencing. I'll just bring up the objectives, sorry. Apologies. It's got a few documents and big tables and little screen. Yeah, so key, just moving through the provisions. Yeah, so that objective put forward by Mr. Kiss, just I guess there's that request for recognition that some things can happen in SNAs, and providing that the effects are managed, then yeah, I can see some merit in that suggestion. There's a objective requested from Waka Kotahi that states recognise some activities can locate within SNAs where effects are suitably remedied, mitigated, offset, and specific circumstances managed by environmental compensation. So I did sort of back those submissions off in my section 42A report, and I am comfortable with that, but just noting what Commissioner McMahon's been, the comments from Commissioner McMahon about needing to go up and down. So I will give that a bit more thought, and that will be on the table at the conferencing. So I've already talked about Eco P1, where I will include a 5th clause to be determined. Eco P2 about maintenance and the submission from Waka Kotahi. This is related to their request for a new definition on regional biodiversity value. I maintain my position in the 42A report. I wouldn't like to limit that policy because we're relying on that to feed into the zone chapters and the subdivision chapter just to get some good environmental outcomes. So I wouldn't like to limit that to, biodiversity that needs extra ecological in all cases, expertise in all cases. And Ms. Calland has recommended the wording encourage the maintenance. So I'm happy just to retain maintain. Eco P3. Ms. Ratt has recommended more careful drafting to the opening of that, which I'm quite in agreement with. The opening sentence of that could be clarified. So she suggested only allow Indigenous vegetation disturbance within SNAs or in the coastal environment, so I think that actually tidies that up, takes out the end. But yeah, again, and then there's the questions around separating new and existing and regionally significant infrastructure. I think we need to do a bit more thinking about the regionally significant infrastructure, whether I think I stated that I've looked at the definitions of network utilities and infrastructure, and at some point I'd satisfied myself that the likes of Transpower were included, but and now I understand that they're not network utilities, so I need to go back to the drawing board, because that certainly is the intention, that Transpower, Trustpower are treated in the same way as other as network utilities. And earlier when I was speaking about the coastal environment, I indicated that I would be open to adding another layer to policy P4 to ensure that stepped process and policy 11 of the NZCPS is adhered to. Still in contention with that policy is whether we're talking about significant residual effects or more than minor residual effects. And my arguments that I put forward in my report and at the start of the hearing, I maintain. I think after I've just stepped through this, it would be useful to ask Mr. Shaw to talk about some offsetting and compensation and the application of those concepts. There, in Eco P5, there's an implication with that for the amendment to Indigenous vegetation disturbance. And so I would like to talk about the trimming and the concerns raised by Trustpower, because, I mean, regardless of the activity status, if you don't meet the permitted standards, my reading of that rule is that what Trustpower wished to do at that tail race in the SNA would be a permitted activity. It would be maintaining their existing infrastructure. And so when Dr. Herbert and I went to on that site visit, and there were particular trees and that they were concerned about, and Dr. Herbert's advised that one in particular, which was on a lean over the river, was not Indigenous. That's correct, Dr. Herbert? Thank you, I can see you nodding.
Yes, that's correct. It was a very large senescent holly.
So yeah, I just feel like some of the submissions from the NU companies, yeah, I felt that the workable rules approach and stating that their work necessary to for their ongoing operations was already provided for. I mean, there does raise the question of upgrading, but that's not a permitted activity, and then that's that consent pathway, which I feel it is reflected in the change to policy P3, but we'll work further on that.
Just when you're talking with the other planners about that. Having worked for a lot of network utility operators, the preference is always for discretionary or better, because that's anticipated and provides more certainty. But obviously the things you were talking about is if there's a clear policy pathway for the sorts of things they anticipate on upgrading, you know, there will be a topic of conversation, because once you are through a clear policy gateway, you're in business again. So yeah, you'll understand that as a consenting person.
Yeah.
Yeah.
So I'll just park my thoughts on that when I get to rule 1. Just on the matter of upgrading though. So it's a matter of contention. It's come through some iwi submissions. They feel that upgrading of infrastructure should not be permitted. So I would just clarify to Ms. Benson and others that raise that concern that my recommendation for permitted upgrading relates to R2, not R1. And that's on the basis that under Eco R2, as well as the list of permitted activities, the limit of clearance is 100 square metres. So there is a scale and scope around what disturbance could take place, whereas R1, there's no permitted in there. And upgrading. So just a matter of plan integration, and in the network utilities chapter, I just bring your attention to rule NUR3, which relates to the upgrading of above ground network utilities, and it provides a scale for the upgrade that could be provided for in that rule. And so I do see there's some potential for integration either within linked to that rule, or perhaps some of the details in that rule could come into a definition of upgrading. So I think that's possibly need to talk to the author of the network utilities chapter, and but I will try and give some comments on that in my written right of reply.
I think that's useful, because as we know, we have one party lobbying pretty hard to put everything into the network utility chapter that could possibly be of interest. So liaison with the author. Who is author?
Hamish Vesney.
Okay. Yes. I certainly encourage that.
Yeah, and to discuss that in the conferencing as well. So DOC and then Forest and Bird in adopting their written submissions are seeking that we separate offsetting and compensation. So we would remove offsetting from P6 and put that into a new policy just for compensation. So I maintain the position I had in the section 42A report. I feel that at this policy level, they can be grouped together. The concerns about them being conflated, I feel that policy P4 steps out the effects management hierarchy. It doesn't say that offsetting and compensation are the same things. So it does direct that offsetting should be considered first, and recognising that compensation is to deal with the things that can't be offset. And also that where you get to that point and compensation isn't appropriate, that the activity is avoided. So I feel that P4 with the effects management hierarchy is the hierarchy is quite well stepped out in my view. The problem with that policy is more at the start of it to reflect the coastal the NZCPS.
Yes. Do you accept that, or is your opinion that there is a hierarchy between offsetting and compensation, or they just have different purposes?
I think it is preferable that offsetting, because it's measurable, it's got a slight a higher degree of certainty. that the effects from the project are going to be addressed. So, but I would invite Mr. Shaw to provide his thoughts on whether they can be grouped together and that hierarchy, if that's okay.
Sure.
I think you've just summed it up really well, Ra. Offsetting provides a lot more certainty generally, and compensation is often regarded as a last resort. That's not always the case though, because sometimes compensation may be a way of providing possibly a better outcome for otherwise what could be a very expensive process through and costly process through offsetting. Dr. Herbert.
Oh, sorry, I was just going to say, Mr. Shaw, how the herpetofauna and the Mount Messenger bypass was a good example. Great lengths were taken to try and offset, to try and measure the values of that component of the ecosystem. Experts agreed they probably were there. They couldn't find them, and so if you don't know what's there and what are you measuring to provide a meaningful management of, and they looked into a considerable enclosure to put them into if they salvaged, and the experts couldn't agree that, but a lot of work went into it before compensation was considered. So I think that's a really good example. And then you think of the invertebrates and things that are just very hard to find to measure. Sorry, Mr. Shaw, were you done?
I am. No, I think you've covered it very well, Ra. And that was a good example from Mount Messenger.
So I am comfortable with P4 and P6, except for the starting sentence of P4 and the start of P4. Okay, so there was some talk around the use of the word scheduled, and I'd just like to clarify that in Eco R1, the fact that scheduled is still in that header is an error, so I will be recommending that be removed. I'm not seeking in these rules to have scheduled and unscheduled SNAs. I hope just to clarify that these rules are about mapped and identified SNAs.
Okay.
Thank you. Yes, so R1 is certainly going to be a key subject of the conferencing. And, I am reconsidering the non-complying activity status. I think you can understand what I'm trying to achieve with setting that bar high, but I think it was Ms. Ratt in her original submission noted that the policies and objectives should be able to manage the effects and provide the ability to decline the application. And I think that P4 with that stepped process, and then the last bit of if you can't, then you avoid the activity. I feel that those policies are fairly strong, that, I am open to reconsidering that non-complying activity status. And then the question of whether we have controlled activity or restricted discretionary for those things that might have a lower impact. I'm entertaining the idea of providing you with a few options for that rule. So one being try and figure out if you can have the middle ground a bit more separated out. But at the moment, I feel that turning it restricted, fully discretionary might be where that's my current thinking. I might land there.
And certainly we're open to having options put forward where to us. Some of the authors did that in the rights reply and hearings 1 and 2, for example.
Yeah.
And we felt, we could then think about those things in terms of our own experience and judgment on those. And so that's certainly a good technique where you're perhaps not 100% sure and there's more than one way to skin the cat. So, certainly don't hesitate to do that if that's a way through.
Thank you. Yeah.
Something that's you're not quite certain on. There's this way or that way, and
I think what's prompted me to really reconsider that activity status is, I made those comments at the start of the hearing about having processed quite a few non-complying activities, and they often weren't a big deal. But having heard the evidence of Mr. Kiss and feedback from Ms. Johnson as well, I've been advised that they spend a few extra days on those non-complying applications, and essentially they will be this activity will be considering the eco policies and objectives. So perhaps in the interest of the cost consideration, that's altered my view.
Ms. Macbeth, if I can, I'd offer you some assistance there. The topic of what activity status to allocate activities where you've got these high level policy thresholds in the Act, it's been the subject of quite a few decisions recently. And I'm sure Ms. Wallace will be able to sort of give you guidance if you want some there. At least since the Court of Appeal's decision in Davison, there doesn't seem to be a huge, not much more is added by making something non-compliant, apart from the stigma and the tension that occurs in everyone's eyes when that status comes up. And to some extent, that too can serve a purpose. But the Court of Appeal has said that for a decision maker, when going through Section 104, to ignore very strongly worded policies and to balance them out by other factors would be, would be to derogate from its obligations as a decision maker. So there is a lot of good guidance there that 104 with a good policy regime can really almost derive the same outcome in a way of achieving quite strict adherence to policy. But ultimately, it's a consent authority's decision to make.
Thank you. The non-complying activity status, part of going with that was trying to send a strong message that this is serious. You got to be serious, and you're going to have to seriously manage those effects. But that discretionary activity can, with the strong policies, can do that as well. What I was going to say next. So Commissioner Littlejohn queried the new provisions of Eco R1 being 7 and 8. So you heard Miss Marina Johnson submit about the shade on her property, and in coming to in assessing a response to that, I determined that it wasn't an easy fix in terms of having a setback from a building because of the topography of our region and our district, and in her situation, the shades generated some way away. But regarding the concern about certification and the need to get a qualified ecologist to assess the criteria, I can appreciate your concern from a purely legalistic perspective. However, this is a pragmatic and efficient response, I think, with such a large number of landowners now affected by this. And just it's just a workable response. I did have a discussion with Ms. Wallace about it, and she just noted that in some other legislation, she has seen some permitted standards subject to information requests, such as in the Exclusive Economic Zone Act. So this isn't my, obviously not my area of experience, but I hope you can understand what we're trying to achieve with those, with what I'm trying to achieve with clauses 7 and 8. And yeah, I would like to see those go through. I would also note the quite clever suggestion by Doc that clause 6 relating to Mānuka and Kānuka could be removed if you have clause 8 about getting an ecologist determining it's not significant. So that's I would have some concerns that you know, we need to explore Mānuka and Kānuka in a bit more detail. It's not and just with the relationship and the trust that's been built over the years with some landowners about the Mānuka and Kānuka, having heard all the evidence on that.
I'm very much interested in that 8 point, because it seems to suggest that the exercise of identifying the SNAs is flawed. I guess that's the bit.
Yeah, no, I think what it reflects is that they haven't all been site visited. And when they are, often it's just shaving the edge off. It's just the edge that's not significant, but say a few meters in, it is. So perhaps Dr. Herbert could talk about that from our recent site visit.
Look, I mean, I don't. I'm happy if Ms. Herbert wants to talk about it. It did strike me as being a bit peculiar that you're not allowed to clear vegetation within a scheduled significant natural area if it's not significant, or you are allowed to. So, but I take your point that if you haven't been to all of them, there may be patches of stuff within them that a landowner could come along and say, well, look, yes, I want to clear out this clump of pine trees, for example. But it's within the SNA, and they get a report and take it to the council, and it says, look, the SNA is actually under threat from these pines. So is that okay if they take them down? And council says, yeah, but just don't damage any of the bush when you do it. So
that standard isn't to deal with exotic species, because if you look at the rule heading, it's indigenous vegetation. So perhaps if Dr. Herbert could give a few examples of what might be indigenous vegetation disturbance but not meet the significance criteria. So there's certain species in relation to the area, you know, they don't naturally occur there, or that sort of thing.
Yes, there are a few species that basically have the southern end of their natural distribution just above the New Plymouth district. So examples would be Pohutukawa, Karo, and also, sorry, I can't remember the common name, but Hoheria poponia. And certainly on some occasions, I did see those species within SNAs. And I believe my decisions in those cases were to retain those areas of SNAs based on the fact that they were Indigenous species, even though they weren't species that are Indigenous to the New Plymouth district. Apart from the Mānuka and Kānuka under 25 years old, which I understand is, is being discussed and worked through still, I can't think of any other examples of native vegetation clearance, but perhaps Mr. Shaw might be able to help out with this one.
Yeah, what was this provision put in for, Ms. Macbeth? Just remind me. This was obviously a response to someone's submission. Whose was it?
There were submissions along the lines of all SNAs should be ground truthed.
Oh, okay.
And
that's what it was.
Yeah. And also, so this isn't particularly within scope, but something since these have had immediate legal effect, we've had quite a significant enforcement need occur, particularly in New Plymouth City with the urban SNAs. So we've had a few cases where there's been quite a bit of angst for people, whereas if they could, whether that they don't believe that it's significant, so this gives them the opportunity to demonstrate that, and then they'd be off the hook.
Okay.
And alternatively, the resource consent could be the appropriate way to, if that was dropped, then a resource consent. And if it is minor and it's not significant, then that would be a very straightforward resource consent that the council would process for free anyway.
Just organising some power here, rather than laptops running out of juice.
No. Going a bit longer.
Yeah. Okay.
In relation to the clause 7 and the requirement for an arboricultural contractor to carry out the work, so it's pretty late in my reporting when I added clauses 7 and 8 in, and I took that concept out of our notable tree chapter. And however, Mr. Shaw has advised me that he doesn't think that you'd need to get an arboricultural contractor for SNAs. So, you know, the landowners can do that work themselves once we're satisfied that it's permitted, and in the interest of saving additional costs for landowners of engaging a contractor. I'm intending to recommend removal of, and the work is undertaken by a council approved contractor. So would you like to talk to Mr. Shaw about that, about the difference between like a notable tree and a SNA area for that approach, or no? Okay.
I think that's understood.
Can you confirm that, Mr. Shaw, that's your view?
Yes, that's correct.
Thank you. Okay, so I think let's move to Manukau and Kānaka. So that's clause 6 of Eco R1. I think we've outlined in the report the reasons why that was included. And we've heard a lot of evidence from tangata whenua and an ecologist, Mr. Lacock, I believe. So just offer that the floor over to Mr. Shaw to outline his evidence on that matter. Thanks, Willie.
In paragraph 10.5, I've said, I'll just read it out actually. I'm comfortable supporting this permitted standard given the history of clearance and reclearance and the relative abundance of early successional vegetation dominated by Kānaka and Manukau in this particular ecological district, and I'm referring specifically to North Taranaki. And the history there is that, I mean, there's an extensive area of Indigenous forest. There are a lot of farms in those valleys. They've had a multi-decadal history of clearance and reclearance on the margins. So there's a lot of younger secondary vegetation, often heavily grazed, goat infested, depauperate understories. Really quite difficult to ground truth every site, and it's similar provisions have been applied in other districts, other ecological districts, like the Eastern Bay of Plenty, for example, where there's a lot of Indigenous vegetation left, and there's a long history of clearance and reclearance for farming on the edges, and I'll emphasise that, only on the margins. So really it's a nod to the recognition of long-standing land use practices on the margins of these large tracts of Indigenous forest and the realities of farming in those places.
Mr. Shaw, I mean, I appreciate your views on this, and I don't want to sound as if I'm being critical, but I'd understood you were assisting the council with assessing whether vegetation was significant or not in reaching an evaluation of whether or not a particular land use ought to be favoured over another. And so do you accept that a reasoning around the history of clearance and reclearance is not really a reason that goes to the significance of the vegetation? That's a planning issue and it's a land use issue, but it's not something that you're really qualified to give overall advice to us on, is it?
I think there are two steps here. One is the assessment of significance, and whether or not a site is actually or potentially significant. And then there's another step, which is how do you recognise that significance, and in some cases recognise what's been happening in that landscape for a long time. And I have been giving, as an ecologist, giving advice to district councils, regional councils, central government agencies on land use practices as well as ecological significance for decades now.
Well, I don't doubt it, but I still wonder whether that's your job, frankly. And look, that's one aspect of it. The other aspect of it, which I think, well, the other reason you've put out there, which I think you are on strong ground to talk to us about, is your second reason is what you've called the relative abundance of early successional vegetation dominated, because the abundance to some extent does go to the criteria of significance, doesn't it?
Yes, it does, and it also it relates to the resilience and the ability of some of these systems to deal with some degree of modification on the margins.
Talking about, I mean, this particular exclusion in the rule would only apply to Mānuka or Kānuka that's actually been identified as being within one of the mapped SNAs, wouldn't it?
Yes, that's my understanding.
So from all of, and this Ms. Herbert might help us out on this, could you give us a sense of the SNAs in the North Taranaki Ecological District that are still a part of a working farm and comprise mature Kānuka and Mānuka on the edges?
Could I possibly address that in the written right of reply?
Yeah, sure. Look, I'd appreciate that, because we're not, I mean, the concern here is, well, there's two concerns. One, there's Mānuka and Kānuka that might be taking away on land that's been actively used for rural activities that just happen to be on the edge of an SNA. And I'm certainly well familiar with those sorts of situations, and laying paddocks fallow for a while, going back in and clearing them after a few years so that you can extend your pasture and all of that sort of stuff. And that's all fine. And that's not covered, as I understand it, because it's not SNA. It's just, unless it's in the coastal environment, it's sort of up for grabs, isn't it? So a farmer's got no qualms about going out and slashing back over those old paddocks that might have taken away with scrub. It only really bites if that area has been mapped as an SNA. And so we're only talking about Kānuka and Mānuka that might exist within a mapped SNA.
So certainly there were some cases where farmers, in fact, actually Mark Andrews' property is actually quite a good example of this, where an area that had been previously cleared had been left to grow back over in Mānuka and Kānuka. And again, you could see that it was on the edge, or sort of within the elbow, if that makes sense, of an SNA. So it did, from that one in particular was a desktop analysis, because it was a further submission that came through a bit later, I believe. But from desktop analysis, we were able to confirm that I think it was about 20 years ago, that site was still pasture. So, I mean, the reason I'd just like to perhaps defer giving exact numbers until the written writer replies that I would like to give exact numbers rather than saying, oh, 10 odd, wrong.
Commissioner Littlejohn, could I just add that
Sure.
This, from a planning perspective, this isn't about an existing use right. I'm not claiming that they have existing use rights. It is about balancing the need for an economic use of the land, where in this area, so much, some of our people that we visited, and I asked Ms. Fleming to point a few out to you. For example, the Thorbies, they've got about 1,500 hectares of land and 800 hectares is SNA. And it's just recognising, I'm pretty sure this word isn't in the RMA, but just an element of reasonableness. They've got...
There is a specific provision in the RMA that deals with it. It's section 185. It essentially says there's no compensation for the impact on a landowner of a rule that is necessary to achieve the purpose of the Act, but they can apply to have that rule taken off them if the rule renders their land incapable of reasonable use or is an unreasonable burden. So there is a mechanism there. And I appreciate that it's part of your job with your Section 32 analysis to always bear in mind that you don't want to make the use of land the land that's been zoned for productive purposes unable to be used for that purpose by way of another rule. So I understand the issues you're sort of grappling with. It just I must say 25 years really just suggests to me that it's well beyond ever being historically or reasonably used for agricultural activity, and has been given up on. But look, we haven't had a lot of evidence either way on this, to be honest. And I guess that's why my questions seem to, well, probably appear to be a little bit vague, because we didn't have any farmers come along, because I imagine they were quite happy with it. But
a number of submitters who from North Taranaki who do outright oppose the rules-based approach. They did say, look, if you're going to keep it, you've got to keep this provision. So there's a few of them. Right. And just the other thing, in terms of abundance, Mr. Shaw and I have discussed the potential for amending that clause to limit it to the North Taranaki Ecological District, so that it would be removed from the Egmont Ecological District. So,
okay. While I've got Mr. Shaw and Ms. Herbert there, in other cases I've been involved in, and it was Thames Coromandel, for example. Thames Coromandel, exactly the same issue. Lots of steep terrain, farms that go, huge elevations, and a lot of the farmers up there use the Manuka and the Kanuka for stock sheltering in the pretty terrible weather on the up around Colville. The ecological advice, and I wasn't in a commissioner role then, that I had was that at 15 years and or circa 6 meters tall, the scrub on the edges of SNAs in the Coromandel, and I appreciate it's a different ecological district, was starting to develop an understory, and other successional species were coming through. And so hence the 15 years was set as a threshold of, yes, it's come through, but it's not at the point where it's succeeding into an expansion of any sort of canopy species or forest, so it's okay to take it out. The 25 years and 8 meters here, I mean, are you able to give me some ecological information about where you might see such a successional trend happening in the North Taranaki Ecological District? I mean, presumably it's a little bit colder, so we've got other sort of environmental factors that might be inhibiting the rate of growth or expansion of forest. Have you got any advice you can give us around that?
Yes, it is further south, and the growth rates are slower. So the height increments are slower. Almost all of these valleys are also heavily goat infested. So the understory is feral goats. So it is very, very different to Thames Coromandel. I've done a lot of work in Thames Coromandel as well. These systems are quite different.
Okay. I know that. Look, I suspected as much. So it was quite good that you've confirmed that for me. Thank you. Yeah. Ms. Herbert, did you want to add anything?
Yeah, the only thing I'd really want to add is the areas of Manuka Kanuka that I had considered to look a bit borderline, whether they may or may not be under 25 years. Generally, the understory was pretty undergrazed from my understanding, so there'd just be a few species in it, but not the same as a forest that doesn't have grazing ungulates in it. That's all from me.
So the real challenge then is where you've got Kānaka and Manuka stands within an SNA, the real challenge is to convert it into a protected SNA, isn't it? Because then it's going to get fenced and the goats are going to get kept out, and then it's going to succeed a little bit better. Yeah, okay.
Oh, just to add to that though, if those small areas of Manuka and Kānaka are contiguous with a much larger area of the SNA, the problem is usually that the feral goats are living within that much larger section of SNA. So you basically have to shoot out all of the goats in order to actually protect the regenerating vegetation for fencing.
Yeah,
so be practical.
We heard from submitters who shoot hundreds of goats in a couple of month period, and they just keep coming. There's huge areas of dock estate up there that, you know, somebody might be actively managing the goats on their farm, and then they just spread out. So the goats are major up there.
Just like the wildlings, perhaps.
Yeah. Oh, look, I've explored that enough now, Mr. Chair. Thank you, Mr. Shaw, Ms. Herbert, for allowing me to answer those questions. That's good.
Okay, no problem.
Okay, so let's check that I'm ready to move on to subdivision. Yeah, so subdivision got quite a rework. I just would like to explain how before we notified the plan and we pinned down the drafting of Eco R6, that it was sort of designed to look like R4, so it could be one or the other. And I've outlined in my report how it's resulted in every subdivision that has an SNA having the expectation that there's a consent covenant or you're a non-complying activity, and that was not the intention. So hopefully in the report I've spelt out what the rule was trying to achieve, and have done some work with Miss Lawrenson, but just noting that when I was finalising this report, she was still trying to figure out her subdivision provisions as well. So anyway, I have suggested, in light of submissions from QE2, the removal of R5, which was solely to create a lot that would be legally protected. And I did find the QE2 reasons compelling there in terms of not having that landowner association. And I felt that if someone did want to create a lot purely just for that covenant, that could be dealt with under Eco R5, under Eco R6, which envisages additional allotments. So Eco R5 has been restyled to as an overlay rule to apply to all SNA subdivision, to set out that we want so where boundaries or building platforms are going to be in close proximity to the SNA, we've got some matters of control and that assessment there. So the controlled status is intentional because R5 would still be subject to the subdivision allotment size rules and the effect standards under the subdivision chapter. So R5 is about managing the effects of subdivision on SNAs, and a key thing is setbacks.
It does more than that though, doesn't it? It actually operates a little bit like, well, it operates like the other overlay rules in that not only does it control setbacks and the like, but it enables the consent authority to impose conditions, for example, that require fencing, require a pest management and animal control plan, and enhancement of edge planting, which is I mean, it doesn't require formal protection, but I would suggest that these sorts of matters would end up as consent notice conditions anyway. Yes. And so you end up with de facto protection to that extent. which would then work in conjunction with your overall rule R1 to essentially protect the bush, get it fenced, and get pests under control without a conservation covenant occurring. Is that how you see it?
I'm not really seeing that direct link to R1.
Well, no, I'm just saying that even after the land's been subdivided, R1 still applies because the bush is still a significant natural area.
Yes.
So that provides the thou shalt not disturb imperative, and all that the R5 has triggered on a subdivision of the land is that the bush get fenced and managed properly.
Yes, and if there's if the subdivision, so and through the subdivision that the SNA, it doesn't end up in different allotments. Hope that made it through.
Yep. Well, and what it does is it then incentivizes, to some extent, it incentivizes the use of Rule R6 because, you know, to some extent, the combined impact of a subdivision with conditions under R5 plus R1 is sort of like a de facto conservation covenant anyway. So if I'm going to impose those things on my land, I'm going to get a bonus allotment. So I'm going to go that path and get the more rigorous protection of the conservation covenant. So, yeah, no, I was quite pleased to see the rethink of that rule because I think it is quite critical as an overall tool in the toolbox to protect these areas.
Yeah, and when it wasn't drafted that way, I was pondering whether the protections in the subdivision chapter would do that job.
I don't think they
weren't
do.
Specifically mentioning SNAs, and Ms. Lawrenson's amendments to the subdivision chapter, you know, she's very much strengthened Indigenous biodiversity, which I think will provide that length. You know, you would need to consider how significant the vegetation is. And also, I note the matters of control to include the role of tangata whenua.
Mm-hmm.
And yeah.
All right, cool, thank you.
And so R6, now Miss Lawrenson's here, aren't you, Miss Lawrenson? She might have her kids around her, but yes, so appreciate this is not perfect because we've got sort of permitted, well, standards that you have to meet in order to become discretionary, and if you can't meet them, you're still discretionary. So we want it to be a discretionary activity to consider extra allotments. So if you've got a smaller balance, you could have one more lot. If you've got a bigger balance, you could have two more lots. And then if you look at P7, depending on how significant what you're protecting is, you could have a crack at getting more if you're going through a really good process and getting some good design and environmental outcomes. So come back to that question that Commissioner Littlejohn asked me on the first day about how threshold for how much SNA is protected and scope. And yeah, I have thought about, Nicola and I have thrown this around a little bit, but it's just a very case by case situation from my experience with the inquiries we get, and certainly wanted to remove the non-complying activity status from an incentive rule. That didn't seem to be helpful.
Understand.
Questions about that rule?
Yeah, I think that's an appropriate approach, really, because I mean, if I'm a landowner who's got a massive piece of bush and I want to come in and put 100 houses there and go to the council and say, look, I'm going to protect this, I want 100 houses, then you'll go, well, that's a great outcome, but there are other policies within the rural production zones around maintaining rural character and productive land use. And so you're going to push up against those policies anyway. So to some extent, the area of the land becomes a bit self-regulating in terms of the number of houses it could potentially accommodate. Yes. And that's certainly the experience I've had around some of the farms around Auckland anyway. So I think you'd be in trouble now to be starting to restructure it to allocate lots based on how much bush you had. I think you better sort of stick the course, really.
And just a general observation in relation to 5 and 6 is that typically when I see a rural subdivision with a few smaller allotments off, they're usually way away from the SNA. So, you know, this process can open the door to getting some good outcomes for the SNA, but also in some cases, the effect of the subdivision on the SNA is negligible. So it just gives landowners some options, I think.
Understood.
But not sure whether those, I'm not, so it's a discretionary activity where I'm not 100% on whether they belong in the rule or in a policy, or so yeah, I'm surprised you're not hassling me about that.
Perhaps it's because I'm not entirely sure what you're talking about.
So it's a discretionary activity, and we've got all these things that you need to meet to be one, and then if you don't meet it, you're still a discretionary activity. It's not your sort of standard way you'd work through a rule.
So just take me to, I mean, I've got your track change version at the end. Just talk to me where it happens. I mean, I see R6 activity status is controlled.
So that's for
if you're using a conservation covenant.
Yeah, so controlled, if you're using a conservation covenant, you'll have a 4 hectare, if you've got a 4 hectare balance, you can get one more, you can get one more lot. So that's okay, that cascade's fine. If you can't meet any of those, you would drop down to discretionary, which is the first standard in that discretionary, so you can't comply with the one above. And then another option to be considered as discretionary is that you've got a 20 hectare balance and you can have 2 lots. And
yeah, well, okay.
And then the third one is that you and we've put the subdivision effect standards in there, bearing in mind that this rule would replace R4. We've got the effect standards referenced in there. So it would also be a discretionary activity if you can't meet one of the effect standards, which is related to subdivision chapter in terms of, lot sizes, access and things like that.
I think I'm a bit lost still, but that might be, did you prepare a further revision and send it round to us before the hearing?
So I email the published version just lost Eco R6 too. And then when I realized that 2 weeks before the hearing, I emailed the submitters on the rule, and then I presented an addendum.
Okay, I'm just trying to work out. I do remember seeing it, but I'm not sure whether I printed it or not. And that's probably why I'm sounding really dumb at the moment. So I don't have the other rule there, but I take your point. We'll have to work that through.
Yes.
Yeah.
Ms. Macbeth, is that the version with the yellow highlight?
Yes.
Yeah, okay. Thank you.
Just trying to work out where I saw it.
It was handed up on the day, I think.
Start of hearing 1.
So that's why you might not have got it, but may well have been emailed.
Did you get our speaking notes at the start of the hearing 1?
Yeah, I did. I'm just now just
should be with that.
Trying to work out where it is.
Just while Kit's looking for that.
Yeah, thanks.
Yeah. Oh, sorry, Kit, you go ahead.
No, I'm just tracking it down. You go, David. Yeah.
I guess the question you're expecting, Ms. Macbeth, is why is the default status on a discretionary activity a discretionary activity? Is that what you were sort of anticipating? Yeah. So that sort of circular argument.
Yeah. Because I'm quite happy with what we're intending, but I don't think the rule is completely bulletproof right now.
Yeah. I've had experience where discretionary activities default to discretionary activity, and Wellington City, Ms. Edwards will be familiar with this. The difference between the two statuses is one has the benefit of a non-notification clause, the other doesn't.
Okay.
So yeah, we're not getting into that at this stage, but I have seen it happen before. But you're right, you'd normally expect it to default to a higher, a more stringent activity status, wouldn't you?
Yeah.
Yeah.
But being an incentive rule, that seems silly.
Yeah.
But I guess I guess subdivision will be very much in your mind in the coming month, and
Yes.
be happy to keep talking with Miss Wallace and Miss Lawrenson, and potentially where you land with the rural subdivision, or you can any concerns with the rural subdivision that would need to be considered alongside this. So perhaps revisit this at the subdivision hearing if you felt that was needed. You could instruct me on that if you.
Well, what are the thoughts on that?
Given that Eco R6 is the only other true subdivision rule out of all the other ones that are not in the subdivision chapter, I think, I'm not sure, are we all four of us sitting on subdivision? I don't know if we are.
And Antoine's not.
Yeah.
But that's okay. I think we can provide the continuity there if that was.
Yeah. What I'm saying is it might be quite good to come back to this particular rule in the context of the subdivision hearing, and because it has to work alongside and not be inconsistent or conflict with the other subdivision rules, and it needs to be rational. So I'd be happy. I'd support that if that means that we end up with a better outcome.
And also noting that through the conferencing process, Commissioner McMahon had indicated that subdivision should be on the table. So, I can speak to the likes of Miss Bellamy and the other planners that have an interest in that rule. And yeah.
Sounds like a plan.
Okay. Okay, so that's that got us to the end of the provisions. And so I guess move on to the individual sites that we've had people submit evidence on whether they should be in or out, and boundaries. And
before you do, Ms. Macbeth, I've got two generic questions relating to the provisions that I've been just holding back as you've gone through. Would it be appropriate to just
thank you
do those now? Thank you. So the first theme that I'm going to introduce is the issue of alignment of language between the policies and the rules, and within the rules themselves. So, I mean, there shouldn't be anything new in what I'm about to say, because I raised it on day one. And and I'll just give you an example. I mean, obviously, Eco Policy P3 provides, and these comments are regardless of whether there's a consent pathway or not. So that I think these issues apply equally, whether there's a consent pathway or whether we rely on non-complying activities with some policy relief. But in Eco P3 1B, the policy relief is for regionally significant infrastructure. And so, as I said to you, I'm not seeing that come through in the same way in R1 or R2. So we get reference to infrastructure, and we get reference to network utilities in R1, and we get reference to network utilities in R2.
Yeah, so I think, I mentioned earlier that I wish to liaise with Hamish Wesley, who's doing the network utilities, and is he doing energy as well? Yeah, so I think that's I need to follow that up with him.
It's an important point, and there may be some efficiency and effectiveness arguments applying to what term you land on, but I presume you chose the term regionally significant infrastructure in the policy for a good reason, but I'm just wondering what that reason was.
It was in the back of my mind that we would probably need to define it. I think one of you has raised the question of scope for having a new definition for it. One submitter
has provided in the definition of.
Yeah, I can look into that. One submitter has made the submission. If a new definition for RSI, then something else. So I'm not sure if that provides a scope, but I think it might be a bit of a plan-wide consideration.
Yes.
And
Yeah,
and you know,
so it is a wider set than just network utilities.
Yeah.
And I understand that the RPS refers to the concept but doesn't define it.
Yeah. Although I feel when I read the RPS that I understand what regionally significant infrastructure is in that context.
Yeah, but that's the issue, really, Ms. Macbeth, is you might understand it, I might understand it, someone else might have a different view, and this is where, well, that's a policy, but if that term's to be used in the rule, it's got to have certainty, and there could be there's no room for discretion or redefinition of it. So that's the purpose of having defined rules. So
yeah,
I mean,
so I need to go back and look at the infrastructure network utilities again, talk to Hamish, and it's also will be in the conferencing noting that Ms. Calland has put forward a definition, and yeah, so thank you.
The one is the Greater Wellington Plan.
Yeah.
To tackle this issue in a significant manner. Whatever term you use needs to be consistent, and obviously within scope.
I think Mr. Spirdall mentioned that there's something in the new coastal plan. It might be defined in there.
Right. Well, I mean that could be.
I'll pull that together
in
the written writer reply, and it may be that it actually gets mopped up at the end, but I will follow that up in respect to this chapter.
So that's the issue of alignment between policy and rules, but then there's a need for alignment between rules too, and R1 and R2 is a good example of that. And this may be intentional, it may not, but if you look at R1 in clause 2, it talks about the maintenance and repair of existing tracks and fences, drains and infrastructure, whatever that is, and including network utilities. So the words are maintenance and repair, whereas in R2, so that's R1, in R2, the terms operation, maintenance, repair, and upgrading are used. Now, I know upgrading is an issue in its own right, Ms. Macbeth, but the term operation distinguishes R2 from R1. I know we're dealing with two different resources, the SNAs and the coastal environment, and Rule 1 and Rule 2, but I think there needs to be some consistency in the terminology about what it is that the activity is providing for.
Yeah, I've got it noted in my wee matrix here that I need to, through the conference, seek to understand operate, how that's different to, you know, why that would require vegetation disturbance.
Thank you. That's good. I was hoping you would, and I'm sure you would. I just wanted to make sure it wasn't left to the written writer reply. The second issue is about the consenting pathway, and particularly what activity status you land on. I note that you're having second thoughts about non-complying activity status, and I understand the reasons why that you've expressed today about that. You talked about perhaps looking at a suite of different activity statuses, including controlled activity, restricted, discretionary, and discretionary. I imagine you'd want to retain the council to retain the ability to decline the application. Yeah, so that would rule out controlled activity, which would then leave discretionary or restricted discretionary. And I guess all I'm looking to see in your writer reply is the rationale as to why you've picked one over the other. And for example, if you picked discretionary, fully discretionary over restricted discretionary, the panel would be keen to understand what are the limitations of restricted discretionary that you felt made it inappropriate as an activity status. Was it that, was it that the effects issues couldn't be ring fenced by matters of discretion? And I just refer back to that very clumsy reference that I made yesterday to some case law that I thought the Kaianga Council, Mr. Matheson, had introduced by a decision by Judge Kirkpatrick that talked about, in terms of an efficiency and effectiveness argument, that you should lean on the lower order activity status where the effects can be managed under both in an appropriate manner. But unfortunately, I can't give you that reference. I tried to find it last night, but yeah, it escaped me.
It's very good for me to focus that reply.
Yeah, and just a couple of, I'm conscious of time, sorry, and I know we need to get away soon, but just some quick ones on R1 and R2. Yes, R1. I just wanted to, I misheard you. In the title to R1, did you say you were going to delete or recommend delete the word scheduled?
Yes.
Yep,
That was an error that remained.
Yes. Okay, and something I didn't ask you earlier, what's the purpose of the words not otherwise provided for in this table? What are they important words, or what's their function?
Yeah, they're used. There's a few different inconsistencies. I've been looking at that with the another report I'm writing. I find it a little bit problematic.
Yeah, I mean, IV disturbance within a SNA really it covers it, doesn't it?
Yeah, I don't think it's necessary in that rule title.
Okay.
I think it relates to potentially the forestry permit one.
Okay.
Oh, sorry. On that rule, that's actually something I'm expecting I might, in light of Mr. Larcock's evidence, reconsidering that controlled activity status to RDIS for that one as well. Sorry, didn't mention that before. R3.
Okay. I won't talk about clause 6 of R1, that's been talked about. Rule 7 though, two aspects. Sorry, clause 7. One of the questions I asked you on the first day was, what about clearing to maintain daylighting for driveways or pathway where there was shading? I just want to make sure that you were still alive to that potential issue. You don't have to give me an answer now, but I just if you could come back to us on the right of reply on that, it would be useful. On rule 7 also, you've verbally indicated that you're likely to recommend deletion to the words the work is undertaken by an approved contractor.
Yes.
Yes. Okay, I acknowledge that. Ironically, I had less trouble with that than I did with the words that precede that the council has certified that the work is necessary for these purposes. Like Commissioner Littlejohn, I believe that reserves a discretion to the council on a permitted activity. Notwithstanding what you said about the EEZ Act and the advice from Ms. Wallace, and I've had some experience with that Act, I wonder if we can have some specific response from Ms. Wallace on the vires of those set of words in clause 7. Clause 8, I can see the intent, but I'm just not sure about, again, it's lawfulness. So, but I think Commissioner Littlejohn's covered that off with you. Echo rule 2, and this is my last one. In clause 1, I should have asked you this, and I misread this clause on day 1 of the hearing. Sorry. And I said yesterday I didn't think there were any metrics on that rule, but of course there are. It's 100 square meters in any 5-year period. But I just wondered what the derivation of that metric was.
Well, that's I have seen it in a few other plans, and I guess most notably the South Taranaki plan has that metric, so a bit of regional consistency. It's a pretty small area.
Yeah, I'm not debating that. I'm just wondering where it came from.
Yeah, it was the regional consistency was the main. Yeah.
That's it. Let me just check the policies. Yeah, no, that's good. Thank you for that.
We're moving to the specific areas now.
So, yeah, whether particular sites that we've heard evidence on should be remain identified SNAs. So first of all, I'd like to start with Pukeiti. And so I gave you some incorrect clarification when I said that the biodiversity plan was attached as part of their submission, so that the asset management plan was, and I had read the biodiversity plan and I have since obtained it and I can provide that for you.
Yes, please.
Yeah. So within the operation of that land, there's the LGA process. And so I feel that any departure from the existing ownership and management would have to go through a public process. Just some details that I've, when I read the plan, so within it contains a lot of detail about ecological, recreation, education, restoration matters. It includes species lists, pest management targets and methods, which are very ambitious and being achieved from what I have heard from TRC. And I'm just satisfied that the level of care for the ecology and biodiversity values is very high there. It goes far beyond what the district plan the role the district plan would play. So that was my main argument, that it would be duplication if we keep the SNA on there. And also note that it has a presence of a world famous collection, including exotic species, and the function of that area is much broader than pure conservation of land in a natural state in terms of the education and the collections that they have there. And so those characteristics of that management, in my view, differentiate that site from the SNAs on private land when we've had requests to have them removed. So I listened carefully to Mr. Manu's submission that Pukeiti remain as an SNA. And the role of Section 6E is in my mind. And when I look at the biodiversity plan and the asset management plan and the submission, they talk about the way that it was set up and the role of Paranenehi, Ki Waitotara, and all of the partners in that, and noting that they get reviewed through public processes, that I feel that there is and that it's a public site, that that the public can access the site. So having heard Mr. Manu's submission, that is a bit tricky, but I do maintain my recommendation that Pukeiti be removed, and I have confirmed that the Wildlands desktop would have excluded some of that site based on its reserve status, which was scenic reserve. So Katikari, that was Nick and Dawn from Taranaki People of the Land. And, this is an example where it is very tempting to make a special case to remove an SNA based on that low risk if you look on a case-by-case basis. But then you can also look at Mr. Barrett, Mr. Coleman, Mr. Redshaw, where, they're strongly stating that they don't intend to clear it, that they've got this track record of great stewardship. But in those cases, I consider the potential to sell the property and the absence of detailed and formalised biodiversity management plans there's not the level of protection that I feel and management that I feel Pukeiti has. So I I maintain my recommendation to remove Pukeiti as an SNA and Katikari and the other landowners to remain as SNAs. I just, having mentioned Mr. Barrett, you asked that his land could be a case study for a subdivision. And so, you know, looking at his farm, he has carried out some subdivision before. I think what would be allowed for as a discretionary activity and any more under the rural rules would be a non-complying activity. However, if he was to legally protect, then he would be able to realise 2 more allotments, you know, going through the subdivision process and meeting all of those other assessment matters. But so I think, yeah, I don't know how in detail you wanted me to go on a case study, but the R6 would allow him 2 extra lots if he legally protected, which is the way the incentive rule is intended to work. So there was just one more question I've got noted down here, that Commissioner Littlejohn raised the question of incentivising restoration. And through that strategic direction hearing, we're talking about wanting to improve the natural environment. So the rating relief policy that the council has, you don't have to be identified as an SNA, but you could have a QE2 covenant to protect natural values and you could get 100% rating relief on that land. So I feel that that does provide some incentive for restoration. I mean, the bar is, you know, at a certain level in order for QE2 to be interested, but that's just the only comment there that in terms of incentivising restoration. And then also through the land use and subdivision rules and the references to Indigenous biodiversity, and then the linking through to policies P2 and P7, I feel that restoration is recognised through there. And I've already noted Ms. Lawrenson's amendment for the upcoming subdivision hearing has more emphasis on Indigenous biodiversity. And you'll also see where Mr. Friendly's report on open space zones, there is that linkage, and we'll be talking to all the zone chapters for them to have in mind whether my intention with rules P2 and P7 do actually get considered in those land use in the zone and subdivision, or in the zone rules for land use consents. So that's all I have prepared. Please.
Thank you. I actually have some questions for Dr. Herbert and Mr. Shaw, Sarah and Willie. And this is around the propositions we have about, I suppose, the district-wide vegetation clearance rule, and the position from some submitters that that's another level of protection that just provides, I suppose, the icing on the cake. And I think the way I want to handle this is this whole question of significance. I know, you know, Willie, you and I, we worked together for a long, long time, sometimes on the same side, some on the opposite. I'd characterise you as being a very careful and cautious and conservative ecologist when it comes to defining areas of ecological significance. You can either agree with me or not, but that's how I think of your expertise. And I do note that really your answers to your questions I had about how thorough the SNA identification's been in Taranaki, and just whether you had any more thoughts on that. And as you do that, this question of scale and size of a unit, but we're getting down to some very small areas of defined SNAs currently. Does that signal, yeah, I'll give you two examples, sorry. So, and we might be able to bring these up on the map, Julie. In Sarah's evidence, she's got a series of plans at the back, a whole swag of them. And this characterises the process Sarah's gone through in terms of refining SNAs. Yes, yes, that's right. It's appendix 5, I think. Appendix. No, so I think Sarah's evidence was in appendix 7. It's appendix 2 of that. And there's two particular plans I wanted to go to. The first one was page 40 of all those plans. Getting there. Okay, it's this one. Okay. Can everyone see that now?
Yes.
Yes. So what this shows is an urban SNA with the area in red was, I understand, the initial mapped SNA, and the area in blue is what's been recommended to go forward into the plan. Is that correct?
Yes, that is correct, Commissioner Dash.
Yes. And right at the bottom of this plan, we see sort of a house-sized block sitting there. You know, we're down to quite a fine level of detail. And does that indicate that you've just poured over this district with a fine-tooth comb already, and that we're not expecting to see areas jumping out at us in the future that you've missed? That's my question, really.
No, that's really good spotting. And do you want me to go through the process?
We're getting a bit of feedback coming through, sorry.
Oh, sorry.
It might not be you, it might be someone else.
Business.
Yeah.
Oh, okay.
Yes. So there's that one, and there's another one I'll take you to as well. Perhaps if we can go down to page 47. That's the one, and there's a little yellow square box on the left-hand side there.
Yes.
That looks to be not much more than the house site. So again, just let me know your thoughts. Does this illustrate a very fine scale of assessment?
Yes, that's right. I was just, what I was just asking when there was that bit of feedback was, would you like me to basically take you through the decision-making process for each of those two areas?
Not really. It's a more general question about if, for example, Forest and Bird consider that vegetation clearance rule is really needed, and that goes to the Environment Court, and you have to give ecological evidence to say that, you know, you have been thorough. Where do you stand with that in terms of confidence?
It's a very good question, and it's really the nub of the matter in some ways. I mean, I think this has been done at a level of quite considerable detail, and we've been back and checked at the level of precision which has been applied to some of these decisions. And in the urban areas, we've been looking at areas as small as 25 square metres, and in rural areas, for example, in North Taranaki, a lot of the decision making around the boundaries for the SNAs has been at a scale of about 100 square metres. So we're talking a very high level of detail. Having said that, I mean, you can always miss things. And in principle, you know, the more protection that's applied, the better. As an ecologist, I mean, there's probably not an ecologist in the country that would argue against that, at least to some degree. And one of the problems with ecology is, as time goes by, we're finding out more and more about where cryptic biota live and the types of habitats they're in, and that inevitably more and more habitats are being recognised as being significant, and it's certainly not trending the other way. So we've got, you know, bats and exotic tree stands, we've got lizards and kikuyu, and there are many other examples. But in terms of the recognition of what is likely to be significant in this landscape, I think it's been done at a pretty good level now. If I could just home in on that a bit more, in the Ring Plains, so in Egmont Ecological District, a lot of the forest boundaries are really very stable and have been for a very long time. It's a highly developed landscape, long history of farming, a very long history of clearance back to defined forest margins. So the level of precision and accuracy there is likely to be very high. North Taranaki, there are likely to be areas that have been missed, possibly, but on the other side of the equation, there are areas which inevitably have probably been included in SNAs that, on, you know, detailed review in the field, may well be excluded. The risk on the Ring Plain is really quite low, but, you know, you really don't want to lose any more at all. The risk in North Taranaki, if a few things have been missed on the margins or things are lost on the margins, the risk is very low there because there's a very high proportion of Indigenous vegetation in North Taranaki Ecological District. So there's a little bit of room to move there. But overall, I'm quite comfortable, Stephen, with where it's sitting. It is, though, as an ecologist, and as you said, a conservative ecologist. I've never heard myself referred to quite in those terms before in a hearing, I'd have to say. But I think that's
careful.
Careful.
Yeah.
Yeah, I think that's a fair assessment. I mean, it's hard to argue against general clearance rules or anything that adds better protection in the landscape. The issue in this particular area or district is how to mesh a high level or integrate a high level of protection with the landowner and wider stakeholder community. I mean, and inevitably, whatever you do in a particular place has to be aligned with that environment, both the natural environment and the human environment. We humans are not separate. We're an integral part of that system, and vice versa. So it's got to be, whatever solution is applied here has to work in this environment.
Thank you for that. Do you agree with that general premise, Dr. Herbert?
Yes, I do.
Okay. Look, a follow-up question, and this is on my swings and roundabouts statement I made. When I look through these, Dr. Herbert, in terms of the detailed field studies, they seem to be all pretty much going one way. So you were taking off areas rather than adding on, just with refinement. So that would perhaps, I'll ask you a question, would that be your expectation when you were ground truthing other areas? That's probably more likely to refine rather than expand?
Yes, that's correct. Certainly some of the areas that I saw that had been issues like, you know, bits of macrocarpa, basically spread amongst native vegetation, where it tipped the balance of indigenous versus exotic dominance to exotic dominance. Usually the areas that were included were contiguous with no area of indigenous vegetation. However, in figure A2.13 of my appendix, which is the first one you brought up on the screen, when we visit that site,
we're struggling a bit there, Dr. Herbert, with your audio.
I'm so sorry.
That's better.
Better? Okay.
Yeah, that's much better. Yeah.
All right, I'll loom over you then. Where were we? Oh, yes. So in Julie, if you could bring up that first figure, so that was a 2.13.
No, I think it's.
Yeah, that's it. So property C, when we actually went on to it, we were quite surprised to realize that most of those trees were subtropical orchid species. A lot of them, I think, were cherry moyas. And as far as I'm aware in my experience, and Willie can probably also provide comment, I can't pick cherry moyas out from aerial photography. So I think in the balance, if we were to, you know, I would expect that if we were to ground truth all of the sites, we'd actually be cutting areas out.
Could I please make a comment about that?
Yes,
So the areas that were removed were subject to a submission. So the blue bit that's left, there was no submission on it. So and the drafting of the new provision for Eco R1 8 is acknowledging that that is probably not significant either, but we haven't had the scope to, within the submissions, to visit it post notification to remove it.
Okay. Well, what about the yellow one we saw?
So
okay, McMahon or Coffin? Sorry, I knew that Antoine might have to skip away at 4.
Oh, sorry, it was Antoine.
Yes, okay. Thank you.
yeah, and the yellow square on the Owakura example.
Yes.
So I would imagine that is identified in the desktop, been offered ground truthing, haven't taken it up, and it hasn't been ground truthed. That would be my expectation.
But could we go back to that one, because that
map was to show you
the nearby ones
yeah.
as well. Yes,
so that map was to show you the site we did visit, where
yes,
the boundaries were clipped back.
Yeah, but if we can go back to that one, page 47. So someone's identified that area, that quite small area that hasn't been visited or ground truth, but someone said that this is an area of significant indigenous vegetation by some method. Dr. Herbert, do you know about that site, the square box?
Yes, so I've just been looking at the GIS platform that was used to create those figures, and from what I can see, the criteria it's been assessed against is 3.3, suggesting that it contains areas that are located within an at-risk land environment, which wouldn't be untrue, but I can't, unless there was a rare species there that was known from that location, and it doesn't seem so from the assessment. It probably shouldn't be included just from seeing the properties around that. I think the trees that it covers that have got that sort of yellowish tone, actually eucalyptus.
Okay, look, I think I've got the answers that from your expertise about just the thoroughness and the fact that there's these three distinct areas. We have the Egmont Ecological District, the urban areas, and then the Northern Taranaki ones were quite different. Certainly both yourself, Dr. Herbert, and you, Mr. Shaw, have given your professional opinions to those questions. So I think, despite what may or may not be appropriate with these examples, you have done a thorough assessment, and we are hearing that rather than sort of needing to add extra areas in terms of the overall biodiversity, maintaining biological systems in the district, that's going to perhaps be drawn in rather than be expanded out if you did more work, which goes against my view from an efficiency and effectiveness point of view, and the risk of acting and not acting that comes into it, because it's a lot of effort in my mind to actually go to any next level of information.
Yeah, the ground truthing is just so much organisation, and landowners needing to be there at a certain time, and then scheduling it, and ecologists from out of town, and so yeah, it is a really big deal to do that ground
which I think needs to come out super clearly in the 32AA. Look, that's been very helpful. I do have one other question for the ecologists, and that relates to that additional 0.5 to the matters, the criteria.
The
Matauranga Māori, yes. Just any comments, just from an ecological perspective, of adding something like that into an assessment process?
I don't have any issue with that whatsoever. I mean, the Bay of Plenty RPS has a specific Māori criterion in a set F, I think it is. Sorry, set 3 in Appendix F of the RPS, and I can read it out. I've got it sitting in front of me. Indigenous vegetational habitat of Indigenous fauna contributes to the relationship of Māori and their culture and traditions with their ancestral lands, water, sites, waihi tapu, and other taonga. It's absolutely fine. Anything along those lines. The only comment I would make is that, and there is another full set of Māori-related, Māori culture and traditions-related criteria in the Bay of Plenty RPS as well, in addition to that specific criterion. The only comment I'd make is that as ecologists, we have not applied that criterion. I mean, that's something that tangata whenua need to do.
Would the future see yourselves doing this together with ecologists and mana whenua experts in these areas? That joined up approach, is that the way the future is going to be?
I think it is, because Tauranga Māori is a very valid area of science in its own right, and the integration of traditional Western science and Tauranga Māori is where everything is going. We do a lot of work now in conjunction with representatives from Māori organisations and landowners working alongside. I'm very reluctant to take on the interpretation of Māori values ourselves. I'd much rather it was done in partnership.
Okay, so it's a similar way that archaeologists work alongside cultural experts when we're looking at cultural sites and special places like that. So yes, look, that's helpful. That's all I have. I wonder whether Commissioner Littlejohn or Commissioner McMahon have any other questions for the ecologists?
Just let me go back through the evidence. No, I didn't. It was only I wanted to talk to Mr. Shaw about Kānaka and Mānuka, but that's all. I've done that. Thank you very much.
David?
No specific question, Stephen, but I'd echo your comment about in the right of reply, and particularly in the section 32 AA, just some reiteration and writing of some of the themes that have been captured verbally from Mr. Shaw and Dr. Herbert would be useful, if only to provide a road back to this original section 32 where it described the methodology, etc. I know, Dr. Herbert, you were keen to take us through that, but some sort of reiteration of the robustness of that methodology and some of the themes that the chair sort of extracted from you in written form would be useful in that 32 AA right of reply space. That was all from me, Stephen.
Thank you very much. So I think we have finished the hearings. They're not really adjourned because we're still, I suppose they're adjourned in a way because we're still waiting for your rights to reply. But this is the end of the formal evidence giving part. We did have a date, I think, for the 3 weeks. Did we get to that? Yeah, the 8th of November. And look, before I finish up, just thanking the team, you, Sarah and Willie and Ra on this topic. It's a big one. It's a really important one all around New Zealand, but there's something special about Taranaki in terms of its Indigenous biodiversity, the cultural mix, those sorts of things, the history, and a large amount of Indigenous biodiversity that is retained around the Maunga, and also that mountains to the sea area in the North Taranaki through that area. It's pretty special. And look, Ra, thank you for you're obviously a deep thinker. And that's, yeah, pretty admirable. But you do have an open mind to listening and taking on board other views, which is a sign of a really, really good planner. So, but then at the end of the day, you do have to be firm and make your mind up, which you also do. So we look forward to your right of reply, both you and Denise. And I think we'll see certainly you both back in other chapters, or is this the end of the road for you, Denise?
It's got the rural zone.
Oh, the rural zone, of course. Yes. We'll see you back then. So just I'd like to close on that note. And thank you also for those people listening in today. I'd just like to acknowledge again the mana whenua people in terms of experts, certainly the Taranaki Regional Council team that, don't know whether it's just Chris Spurtle there or others. Really great to have you online as well. And Hilary Walker for the Federated Farmers. I think just having you sitting through and being involved is great as well. So thank you very much for everyone participating. We'll end the recording, I think.
Not a koto.
Oh, we were supposed to do a karakia, but is there anyone that's Sarah or Maria? Would someone like to close us with just a brief karakia?
Sure.
Yeah.
Tēnā tātou. Oh, kia pai te rā. Ki runga ki raro, ki roto, ki waho. Rere rere hau, pai mārere.
You're up. Bye-bye.